Yes,
May I- Item number 12 is Sampan matter.
Item number
12. With the consent of other side, I pray for police trying to take instruction file. Depends. Motor में मतलब इंतजार करते
okay. On the prayer of the learned council for the respondent number 3, 4, and 5, Matras then said John. Full stop. List. When? After?
हैं.
After 4 weeks. Interim order, pass earlier,
Made Peter.
Yes, Mr.
Well, the item number 2021 doesn't look nice also, but today I'm in the midst of a lot many side up matters.
Very
Maybe the first
difficult.
week, my lord. I know that even I felt it. First week, my lord, any day.
Easy. Yeah.
Lord, stakes are high. 35 bighas of land.
Less than that. Pond.
Pond.
I think this hearing will collapse.
Today.
And by 12:15, all are enjoying stay 2014.
No, that's correct.
Isn't it?
Or even next week also, I don't mind.
The next week is difficult because it's some.
Today, I got 2-3 matters. I have to
Okay,
give my reply.
we understand. So
Otherwise, I came
these are
prepared.
the scope and chances for them.
I
They're
told him
efficient.
yesterday.
They're
He said,
efficient.
no client will.
Anyway,
First week, my lord, will
Okay.
fix a date.
on the prayer of the learned counsel for the petitioner, matters then adjourned
Okay, give a date.
and we listed. No, we are not fixing it.
First week.
In the first week of March 2024 on a date to be fixed very soon, because I may not continue this is a stopgap arrangement. So I do not know how that bench is fixing matters, because we make a plan, na? These matters,
Nature,
7
nature.
matters will decide on that day. It's like that. No? Yes.
Deep look.
May it please, your lord. A very unusual situation. But I'm
The interim order will continue till in April.
Partial
very unusual situation. My lord. I'm praying for a listing of a matter today. It has been filed.
What is the
Let the tender receive, my lord. On 26th, it will be instructed. I'm a blood. May it please, your lord. My lord, I beg to mention item number 10 and 11. Ma'am. They are supposed to file affidavit. Till date, they have not filed. Let it be after 10 days.
So we'll adjourn on BTC's matter stands adjourn to enable the BTC authorities to file affidavit in opposition.
After
Least after
10 days.
10, at least after 2 weeks.
Wait,
Obliged.
I am mentioning item number 24 and 25. Your lordship may not
Please
like.
before any other bench without.
Can it be on 14th?
No, I'll not fix any date. 24 and 25 list before any other bench.
May it please your lord. I pray for mention of a matter for withdrawal, your lord. Deeply up.
May it please, Lord.
Mm.
The other matter for 26. They have filed affidavit in opposition. Like file affidavit.
26.
26.
You are for
And 46.
learned counsel for the petitioner. Press for and is granted 2 weeks time to file reply affidavit.
Obliged.
List accordingly.
May I please your lordship? My prayer is for listing 3 matters, lordship.
Mm.
One is 17 matter, 18 matter, another is 23 matter. The last listed was
What are the issues?
non-payment of bill, lord. So next week, I need it now.
You make a prayer on Monday. Okay?
Okay.
Make a mention on Monday.
Take the mention. I would like to file the affidavit.
You want to file?
Reply.
What affidavit in reply you want to file? Huh?
There have been some subsequent
What subsequent development? Tell us.
lordship. You have to 90 Lord.
Difficult. We'll vacating next day then.
What is it filing?
Simply we are asked to give us something that give a list of the director. Whole proceeding is state and 2008 it been staying state. On the prayer of the learned counsel for the petitioner, matters then adjourned and be listed after 10 days. Yes, next.
Interim order.
Interim orders passed earlier shall not be continued. Yes,
May please, my lord.
Yes.
Item 3 and 4, my lord. So these matters may take some time, my lord. Can it be taken up in the second half, my lord? Some, the second half, my lord.
but we will not wait.
My lord,
We
that-
may say that after the other admissions
Yes,
matters, but
after
we
the
will
other-
not say that.
Yes,
date.
yes.
Yes.
Quantum other side at
17 and
79.
here is a virtual mode.
With the last it's not equal.
The rate was fixed, you know it day before yesterday. Then you could have made a request. This is a 2014 method. These methods are pending since 2014. And the petitioners are enjoying an interim order. An adjournment has been sought for on the ground that the arguing counsel is from outside the station. Though this court is not inclined to grant some adjournment on the insistence of the petitioner, matters stands adjourned and be listed on Friday, tomorrow.
May I please, Lord.
Tomorrow is a Friday? Tomorrow.
May I please, your Lordship? Actually, I beg to mention for listing one matter. On Monday, Lordship, when I was in hospital, Lordship, the matter came. So I told one of my colleagues to pass over for the day, but as there is no representative, so matter was fixed after 2 weeks. So matter is very urgent regarding enforcement of railway land. Already the person has started construction on the railway. So may I please request your Lordship that matter may be listed tomorrow, if not possible, then Monday.
Well, already you have passed an order, fix a date or something like that. Right?
2 weeks. So it will be late. Right? Because the person against whom actually we want to implement the person. We thought okay.
Difficult to change that order in a mention. How the registry will, after 2 weeks again we are giving a mention.
That is no. I think it's there
You file an application that destroys the situation, there is some urgency. Will
before registry.
not before, you file an IA or before registry whatsoever. It will be difficult to
Yes, I know.
give a mention memo today itself, yesterday to date was fixed. Yes, next case.
Lordship, in item 2 must have been mentioned by learned senior Mr. Sahewala.
No, not mentioned.
Yes, Lordship, I that Deepak and Company.
Item 2? 12,
12, Lordship.
not 2, 12.
I stand corrected. 12.
Uh-huh.
There is an interim undertaking in that. No coercive action. That's
So interim have passed already. We have extended.
great. But
Interim is, yes.
But I am petitioner person. I filed a requisition in urgent in nature, but it's already filed. But I have got I have fixed on in the Supreme Court on 26th of this month.
Now what is the matter about?
This is some actually 2 petitions are already there.
Hmm.
But there is certain serious matter because I have been,
No, what is your grievance that you
my
have filed?
grievance is that my bill is not being paid by the respondent party against whom which is being filed.
Okay,
And he is trying to create complications. So that is I have filed a case over there. But I don't mind coming on Monday. But problem is that Monday I am to appear in
no, tell us, what is your convenient day?
my convenience tomorrow. But that is
Bring it. Blood. Dismission withdrawn.
Receipt. May I please your receipt? Yeah,
Yes, next case.
My lord, this case, my lord, scan copy of your case report.
We have
My lord,
seen that. Have you gone through the statement of the girl,
Yes.
victim girl, 6 years? Go through it.
Yes, we have.
The learned additional public prosecutor submits that he may be granted some time to go through the
Scan copy.
scan copies of the LCR. Prayer is allowed. Please this matter on
Any day, next week.
next week. Click on give a date.
Hello.
Go through it.
Yes.
The statement of the 6-year girl, 6-year victim.
Apply.
Yes.
16, my lord, CP we have not written. Earlier rejected by your CP.
The learned additional public prosecutor submits that the case diary call for.
No, my lord, actually, it's anticipated well, released before any, before
Yes.
appropriate branch holiday.
Ah.
For a first time it has come, my lord.
No. Earlier there was an order. Yes, 2212 order. There is an order directing to release before.
Appropriate.
So CD is not there.
CP,
Learned
Yep.
additional public prosecutor submits that case diary call for has not been reached. Accordingly, matter states adjourned and be listed on
Morigaon on 13th of March.
13th of March for production of case. Yes. Can you do like this? You will sit, somebody will file a complaint, you will sit, have an inquiry, and you will decide that he has sublaged it, so cancel.
He admitted that, my lord.
Where is that?
My lord, he, as per power of attorney, by showing power of attorney, my lord. He already,
Where is that power? Where is your inquiry report?
my lord. Page 32, my lord. Page 32 is the power of attorney, my lord.
But Mr. Kayum, you are also sitting over.
As per,
When was the order passed?
order passed on, my lord.
2-1. And we are in the month of almost March.
29/12/23 was
Yes,
the
where is your decision inquiry report?
inquiry not done, my lord. As my lord, Lordship may kindly come to the NIT first, my lord.
No, we'll go to NIT. We want to look into the decision.
The General Standing Committee's decision, my lord.
At?
Page 38 is the start from translated copy, my lord. And 39 is the vernacular, my lord. First resolution, page 39, vernacular person, my lord. Person, my lord. Resolution number 1. Second line, বর্তমান কাৰ্যালয়ত দাখিল অভিযোগ মতে বজাৰখন নিজে নচলাই অন্য ব্যক্তিক
Where?
Third line, the first resolution, my lord, page 39.
That
The
part,
first-
okay. But what about Mr. Kayum? What about this allegation that you have not paid the KISS money?
Yes.
Is it correct?
No, I have paid the case, but the fact is that they asked to deposit the entire case. ইয়াৰ
Where is
ভিতৰত
that?
তেওঁৰ বজাৰৰ সম্পূৰ্ণ কিস্তিৰ ধনো আদায় দিয়া নাই।
From where have you taken this decision? On what basis?
Document run sometime, I'll take instruction. Today, the first time it come.
Heard. Mr. D.A. Kayum, Learned Counsel for the petitioner, also heard the Learned Standing Counsel for the PNRD department. Pursuant to an NIT dated 11/4/2023 issued by the Sipajar Anchalik Panchayat in Darang district, the petitioner was settled with Kira Kara Cattle Market for the year 23-24 with effect from 1/7/2023 to 3/36/2024. The settlement so made has been cancelled by the respondent, settled by the respondent. What is this? Darang Jila Parishad.
Right.
Under resolution number 1 dated 29/12/2023, 29/12/2023, on the purported ground that the petitioner is running the market it has been alleged that the petitioner has handed over the market to some other person, and accordingly he has violated clause number 25 of the tender condition. It was further it was a further ground that the petitioner has not deposited the entire his money. Full stop. Where is the clause 25?
Clause 25 is it, my lord?
Clause 25?
My lord.
90.
Huh?
Page 90.
Page 9. Vernacular is at page 22. 23.
Where is the termination clause?
Starts from the 19, my lord.
No, procedure of
Well-
termination, settlement.
Right.
Mr. Kayum submits that though an allegation has been made, however, the decision has been taken without giving any opportunity of hearing to the petitioner and hearing of the petitioner, inasmuch as in terms of clause, where is the kist money? Monthly, yearly,
Monthly, my lord.
where is that?
Okay.
This is the difficulty. Nobody is ready.
He submitted so much.
No, see, Mr. Kayum, your basic allegation is that your basic ground is that there is no notice. So therefore, your case should be that this is the procedure laid down for settlement. This procedure is not followed. You are now trying to find out what is the clause. Second allegation is that you have been asked to pay the entire KISS money. So you'll have to show that this is not the condition, this is the condition under this clause, this is to be paid. So it is not, it cannot be terminated. We are saying this. If you cannot help this court in that,
20 million. Just 22 million.
in as much as it is submitted that in terms of clause 20 of the tender condition, the KISS money is to be deposited monthly and within 7 days of each month. Also, it is further case of the, where is the statement that there is no KISS due, due so far?
There is a due, but my lord, they have asked me to deposit the KISS and their KISS.
Hmm.
I have to deposit the part payment,
Where is that statement?
and the document is there.
No, where is the statement that there is no pending KISS so far relating to
Yes.
monthly KISS?
Paragraph 8,
Paragraph?
page 7. Is by the to his if that has a fine, will take the
No, what? Are you not aware what should be the monthly KISS?
that is
Then-
fact, but my lord, he is well the
Yes, we are.
unless
Just
money.
answer.
Yeah.
Issue notice returnable on given date. Any private respondent?
No,
Returnable on given date. Returnable forfeit. The learned standing council for PNRD shall keep the record ready on the next date. Fix. List this matter on 28.
Obliged.
Also, to kindly come to para 21, my lord. In fact, board took a decision. Para 21 at page 19, my lord. That the petitioner begs to state that the petitioner came to learn from reliable source that a board meeting was held on 28/7/22.
Where is Mr. Sudhir?
My lord, page 19, para 21.
Hmm.
In fact, the decision was taken to refix the revenue,
Hmm.
but it was not given effect. That the
Now, it was settled for,
up to 5 years,
Up-
31st of March 25.
okay.
Hello, in
Now, who is
between,
running this market?
Now today nobody is running. It has been transferred on to corporation.
Hmm.
My lord, actually, my lord, there are reports.
Where is
which say-
corporation? There is standing council.
My lord, what I like to submit, will pay some amount, my lord. Let them allow to run.
So
And in the meantime, let this issue be decided.
let the council for the standing council for a corporation. Okay, you can come from other court.
Fine.
We may have an instruction till Monday. What is their instruction,
Yes,
and we
yes,
can
yes.
think of.
May lordship,
Mm.
lordship, petitioners at a composite from by composition. They lifted the PTS article and distributed the shares of dealers and shares of dealers distributed the benefit.
You are the cooperative society.
I'm the co-part.
Now, these materials are, you collect it from the FCA.
Mine.
Now you distribute it to your shareholders. That
Mine.
is the
Shares of dealers.
shares of dealers. Now, what is this 30%, 70%? This is
This is the
commission.
commission.
Okay.
70% to the shares of dealers and 30% to the
Okay. Now, what is your given?
my lord. Events is my lord.
Hmm.
Kindly produce page 39, my lord.
Is 39.
Page 30. Just like, clear now. the size copy, my lord. There is a cabinet decision, my lord.
Yes.
With reference to the subject stated above, and as per the decision for the cabinet meeting held on 21, I am directed to inform you that share price of dealers margin shall be payable to rupees 143 per quintal of the rice to share price of dealers only for carrying out distributing the food gain to NFSA beneficiaries as per food security center. No part of CSC dealers margin shall be payable to the CPS center from the financial year 2021-2022. My lord, after this letter was put on 13/7/2021, my lord, and this is the letter from the secretary to the director, my lord. And after
Now, where is that rule? 2015 rules.
2015 rules, my lord. My lord, page number 36, my lord.
Hmm.
Page number 36, my lord. The notice.
So if that is they have done in terms of a rule, how can we interpret?
No, my lord.
Where is
No,
letter?
no,
Huh?
this is the year for the financial. I am outstanding for the financial year 2000 to 2021. This is the given
Okay,
fund.
prior to that
My lord.
giving effect to
My
the
lord,
rule,
my lord.
what is their stand?
They already stated, my lord. After issuing this letter, my lord, kindly peruse the page number 41.
Page 41.
Page 41. This is the letter by my lord director, all principal secretary to autonomous council, all deputy commissioners, my lord, and he has directed to release the funds prior to the 2021 to 2022 the shares of dealers.
So April 22 to November 22.
My lord, my
You
lord,
want this period?
my lord, kindly peruse the page number 40, my lord.
This is the amount.
This is the amount, my lord.
So it is Tinsukia. You are Tinsukia.
I am for the Tinsukia, my lord.
Tinsukia, you are the association of all the
Tinsukia district,
Tinsukia district.
my lord.
Lai Police Samobai
My
Samiti.
lord, this the
So Lai Police Samobai Samiti, you have a share out of this.
my lord.
Now what is your stand?
Hi, Philippine my lord. They have 7, my lord.
Huh?
They have 7 on this.
There are?
They have 7. Page 85, my lord.
What do you mean by that? What is the, let us understand in a plain and simple language. What is your stand?
As per my lord,
Whether,
notice 15,
whether anything they are entitled between that period specific March 20, April 20 to
November 2.
November 20. They claim that this is the amount we are entitled. Now tell us whether that amount they are entitled. If entitled, we will pay. What is your statement? You say that when money comes, we as and when we comes, we pay. Whether this amount is payable, whether there is outstanding due.
It is not mentioned, my lord.
My lord, already in respect of the Morigaon, Nagaon, Dorong district, my lord, already this matter, my lord.
Hmm.
Kindly peruse the paragraph, my lord, 80, my lord. This is the judgment, my lord. Page number 80, paragraph 20 and 20. My lord. This is the statement of the respondent, my lord. They are entitled for the period April 2020 to November 2020. My lord.
So there is a statement by the learned advocate general that they are entitled. So what is your statement here?
My lord, in this case, my lord, after if they are entitled, my lord, after verification, my lord, it can be for that period.
That if but creates difficulty, then they will again come for contempt. You take a stand that whether they are entitled. If they are entitled, verify the amount. What is the exact amount? That you will have to verify. But whether they are entitled or not entitled, on your statement will decide. If you say not entitled, then we'll enter into the merit. If you say entitled, then we'll dispose of.
Yes, my lord. And in this regard, my
Or
lord,
you say that their cases are also covered by the judgment passed earlier. Tell us either of that.
I will take instruction, my lord, whether
At 2. At 2.
can it be on a next.
No at 2. Obtain your instruction at 2. If necessary, have a talk with senior government advocate and show the judgment that whether it covers, because there is a statement by the Advocate General.
He is preparing the case.
Okay, call him. Yes, what is the next? Yeah, adjourn. No, Bishop first. Yes.
In this matter, we have been black.
You have been blacklisted.
Yes.
Why?
The reason they have also given in their affidavit.
So this writ petition 4234 relating to blacklisting.
Yes.
And 986 of 2023 is the second NIT.
Yes, Lordship, that is another NIT where we had completed the work, but our final bill they are not released. They are not releasing only for the reason that they wanted to adjust another contract, which I had withdrawn and we are going for arbitration.
Okay. Now it's railways.
No, my lord.
MES.
MES, my lord.
Okay. Now where is the blacklisting? Let us see first. Where is the impugned decision to blacklisting? What is the order of blacklisting?
Which page 16, Lord.
We are taking up the writ petition
423.
Four-
Where is the impugned order?
Lordship, at page 8, their copy, Lordship, that is
Is
16. Page 16 is the type relevant.
yes, Mr. Forrester, I'm not getting anything. What is this? Workload return of control. What is workload return? What is this impugned order? How she is affected by this?
Lordship, their affidavit in opposition in page number.
No, you have challenged this or what?
Yes, Lord.
You have
Yes,
challenged
This
this.
is not completed, my lord.
What is this?
There may be some.
Lordship, that means they are not allowed. We are bidding, it's okay. Their advertisements and ITs are coming, but they are not, they are rejecting us on technical ground.
Where
We
is
can
that?
still bring.
Where is
The
that?
next page, Lordship, page number 70. MSS BP Electrical, bid number this much, reject. That is rejected. Every contract they have rejected.
No, not validated. Being adverse remark in WLR. What is WLR?
WLR,
Workload or something like that.
Correct.
What is WLR?
WLR, I put.
So WLR is uploaded in website. What is that WLR?
to the website. I tried the top. It is not doing anything. It is just that they had admitted in their affidavit in opposition, Lordship, if they have filed.
Where is their affidavit?
Affidavit, my lord, we have
Page
filed
137.
on 13 to 24. Page 134 onward. File on 13 to 24.
In 137 last para, they have stated. It is submitted that you get rid of
Space.
137. In their
Just a
affidavit.
minute. What is the decision of the blacklisting?
Lordship, these notices which they have annexed here, these are all final notices to the contract which they had terminated already. These are notices related to that contract. And they had terminated, they tried to get the risk and cost from another contract. When we came before this honorable court, praying to not allowing them to recover that amount, then they had blacklisted us. These are not notices relating to blacklisting. So they are saying in their affidavit that the respondent authority banned the petitioner from after cancellation of the contract as per procedure. And the petitioner is trying to hide the fact by saying that no show-cause notices have been issued by the department before banning of the blacklisting the fund, which is not. In fact, before taking the decision of blacklisting the fund, the respondent authority has issued several notices to the petitioner from showing this date. These dates are not related to the blacklisting. These dates are related to another contract.
WLS stands for workload return.
So, Pora sir,
My lord, yes.
just come to page 141.
Yes.
Except clause 5.
Yes.
There is nothing.
Before that, my lord, I am showing something, my lord.
Yes.
My
No,
lord,
no. See, we are basically on, we understand your anxiety that this contractor, according to you, started a work, failed to execute.
Yes.
After many notices, please do your job, fail.
yes.
So therefore, you have cancelled the contract. And you have issued contract at the risk and cost of the petition. That, of course, can be a subject matter of arbitration whatsoever. That is a different issue. She can go and file an application under section 9. Everything is there. That relates to a specific contract. Now, you are her name is uploaded in a website, whatever we do not know the meaning, WLR. What we could understand from the basic pleadings from you and her. And therefore, now onwards, whenever she participates, her tender is not accepted or it gets rejected because of the fact that she is in a list which tenders are not being participated. Now, if you go by the law from it that 1950,
My lord.
the law is that blacklisting is to be done with giving a reasonable opportunity of hearing. Now, in a contract, you say we will do this also. Okay, fine, you have given a notice. Where is the decision? Have you let her know? Can you debar her from participating in any country? Because law is well settled that blacklisting, it should be specific. Blacklisting from what, for which period, what are the reason? You cannot do this.
This specific is not
And-
there, but regarding that, matlab, several notice. One thing
No,
is
no, the stand you have taken that we have already issued several notices, except one notice, paragraph 5.
Five.
Nowhere there is any proposition that we will blacklist you. And even we accept that this 5 is a proposition of or a notice, where is your decision?
matlab, that is not
Decision
an
cannot be,
that is not
this is a
annexed
difficult,
matlab, no, matlab, for that record may be necessary, matlab.
but
because,
any interim order?
one thing is that matlab, they have annexed the matlab, they have filed a matlab, additional affidavit. They have page 53 of the tender document.
Hmm.
They specifically page 53.
Page
Special
53.
condition for conciliation and arbitration, that is clause is there.
No, clause is,
Yes.
there is no problem on
Yes.
arbitration. That is not an issue. That
But
will be
we have
subject matter of
blacklisted-
the other writ petition.
Yes.
That is not an issue.
Yes.
Issue is whether you can
Only
stop a person and
for
violate
one
his or her right under Article 19(1)(z) without following due process of law. That's all.
But regarding that matlab, record matlab, because
Another thing,
this-
Lordship, these notices, they started the end of 2019. Then came lockdown, total lockdown. Lordship, Union of India might be able to move around.
No,
but
we are
not
not,
for
we
the
are not
city.
on there. We are
No,
not all.
They did not consider that. They did not, our supplies were ready, Lordship.
If you argue that, we will we will pass a difference.
Lordship, I'm
Okay,
just
if that
stating-
is your argument, let us dictate this order. We need not wait for their
No,
record.
Lordship,
no,
Lordship, I'm just
What is,
stating it
no,
before
don't place which is not necessary.
Sir.
Place what is not necessary. Is it?
regarding that,
Their fundamental issue is that you have been
Black.
blacklisted, admittedly. How, whether they can do this in that way. That's all. There is no
Yes.
specific notice, no ground, no reason decision, no opportunity of hearing. What is the period? We do not know. Can there be a blacklisting for any time to time
no,
memory?
matlab, that is no specific 1 or 2 years must be there. Matlab. So I need to just minimum 2 weeks time. Matlab, I'll just record matlab only because they have provided a affidavit without waiting for me. Matlab, they by their own matlab, give their affidavit. So matlab,
They will face the music.
that
What
is
can you,
difficulty, matlab.
they will face the music.
Matlab, at
They,
least
they have
specific-
become wiser than their legal advisor. They will face. That is not your
I
concern.
have already talked regarding that. matlab,
Yes,
specific-
Mr. Parasar, learned counsel for the petitioner submits that he need to obtain the specific
Specific
instruction
instruction.
and record as regards blacklisting the petitioner and the procedure followed while taking such decision. Full stop. He also submits that he will obtain instruction as regards the specific decision and period for which the petitioner's firm has been blacklisted, which is not available on record. Full stop. Prayer is allowed, list of the fields. The learned counsel for the petitioner has expressed that without there being any specific order of blacklisting and without giving any reasonable opportunity of hearing, the petitioner's participation in tender under the tender under the respondent authorities are being automatically rejected in each and every cases. Therefore, an interim order needs to be passed. Full stop. This court is all of the view that no, not necessary. Such interim order shall be considered on the next date in the event the records are not made available and no and more not available, and the reasons for the blacklisting and the procedure adopted therein are not brought on record.
Regarding the next item, my lord, yes, there is a completion certificate is there, but I have not received instruction. My lord. Actually,
Okay, we'll take both the methods together.
my lord,
Same
Yes,
day, Lordship.
same day.
Same day.
Give a date. Six. Both the dates. You need not pass an order there.
Okay.
Both will come together.
Lordship, March is coming, they can pay now.
Okay.
Taking one part goes.
When?
Today is 22, Malat on 7 Malat.
7th of
Seventh
March.
of
March. Release this matter on 7th.
7 of
Much of that.
Yes,
But this application is for prayer for appointment of an arbitrator.
Yes, what you say?
Lordship, I have a single prayer, your Lordship.
Huh?
As per your Lordship, section 8, your
Hmm.
Lordship 2 of Arbitration Conciliation Act. Your Lordship.
I think this matter is to be taken by that bench only because section 11,
And the amendment of 2015.
section 11 basically it's especially attached to a bench by the
Correct.
Honorable Chief Justice. I think there will be some
Correct.
order.
Let the-
Chief Justice or his delegate.
Correct.
So therefore, list this matter next week.
Can we have a fixed date?
Yes, tell. Under prior to learned contextual parties, list this matter on list this matter on 6/3.
6/3.
6/3.
If you oblige, my lord.
Oblige.
This refers pertains to non-payment of contractual bill. With the Sending Council BTC,
Yes,
Right.
Rava.
any claim over 10 lakh, they have referred it to the committee. Whether the case of the petitioner is also, they were asked to obtain instruction.
But updated result has not been received yet.
Okay, Mr. S.R. Rava, learned standing counsel for a BTC, submits that he may be granted some more time
2 weeks.
to,
time.
or 2 weeks time to obtain instruction in terms of this court's order date 13/3/2020.
They for a fixed date if possible.
List this matter on. You make a mention, okay?
May please your lordship.
Hmm.
Here, my lord, in the incident case, my lord, matter is regarding the interpretation of clause by
Hmm.
the tender. As per my lord, tender to whom and my lord, the value of the tender is my lord, 5 crore.
Who is for the railways? Yes, Parasar was there. Huh? K.
I-
Gogoi.
Earlier date also, my lord,
Then we'll proceed. Yes.
I don't check with
earlier also, my lord.
Okay, we are waiting for something. Your case is that you offered a tender,
Yes, sir.
amount was accepted, you executed,
Yes,
but only on the ground that there is a difference in the tender value and the offered value,
Offer to-
that was returned.
Yes, sir. And their own document, my lord, engineering department has said,
What is
that
their
this-
stand? What is their stand in affidavit?
there's 10 in the affidavit there, the addendum in DCP 2014 matter. There is a clause 50 lakh, which is subscripted was made to the escrow. That contract value is below 15 lakh, he will not have. Actually, that is not correct. That is also-
Anyway, let him come.
Except they have
Now,
said,
what is your prayer?
my prayer before your lordship, that I know, the decision which has been taken, that we are not entitled for the, my lord, PVC.
Hmm.
That may be set aside.
Okay, let us,
And my lord,
let Mr. go.
the tender department has categorically stated that this is the 2019 follow. It is obviously no everything, my lord. When no news comes, that
That will be on a prospective until
Yes,
and
my lord.
unless it is.
yes, my lord. And 2019, my lord, said
According to
nothing.
you, when your contract was entered into,
Yes.
then this amendment was not there.
Yeah.
Subsequently, there was an amendment, so that you cannot make you cannot apply it
Yes, sir.
retrospective.
Retrospective,
It is always prospective.
a second, my lord, you cannot change the rule of the game.
In the midway.
Doctor assessor,
Yes, yes.
And the central call.
Okay, we'll hear this matter after. Yes, who will represent PNRD? PNRD.
I am for 30 and also Milo.
Yes, PNRD. Yes, Dr. PNRD.
Sir, I was appearing in item number 14.
Huh.
We have in the meantime written our Okalatnama, my lord.
Hmm.
And we have issued registered notice to the party,
Hmm.
which has duly been served, my lord.
Hmm.
So, if permitted, my lord, this will be kept as a part of the record and our name. will be-
No, this is, you should submit it before the registry by filing an application.
My submission will be recorded.
Mm.
It
You
has
wait
been
for
served.
some time, you wait for some time, let us see.
My lord, in fact, 13 and 14 become infructuous, my lord.
Why?
Because period is already over, my lord. They have challenged that impugn order.
No,
Period is
okay,
already-
period is challenged, but how have you settled subsequent to that? Tell us that.
My lord,
In a
two
report.
petitions, my
Forget out, we will not look into them.
two petitions, my lord,
Hmm.
filed by the same petitioner.
Hmm.
One
What
for
is their grievance? Tell us first.
grievance, my lord, they have settled, but they are not able to run the market. That is their grievance in the 13 and 14.
And what about 15?
15 is they are the rivals, my lord. 15 saying they are
15 minutes, 3 minutes. I have filed KBA, but copy is not stopped.
What is your prayer in item 13?
In my prayer Miller, there is a Millard government market. It was running by us earlier. Subsequently, sometime Millard in lockdown period, it was closed.
It was?
Almost closed.
Okay, then?
Then it is again started Millard by government was collecting revenue Millard.
Hmm.
Subsequently, we have filed an application for history Millard. I am filing application before the authority Millard. Jila Parishad. They allowed me for temporarily sometime.
Hmm.
Then Millard, there are several letters issued from the district commissioner Millard and also from Jila Parishad to the BDO to
No, what is your grievance? You want to run the market or you want something different?
I still in the first my submission to lordship. I was running illegal. There I am submitting holding. And with my submission to lordship, first let the land of market be demarcated by the BDO or by the DC or by the supervisor.
Hmm.
Then we'll issue NIT and then settle the market as per law.
What is your prayer?
My prayer will
Now, who is collecting revenue?
now will at present it is
their term is over.
now
No, their term is over, but if they are an intending tenderer, if you are not doing it through tender process, they can still have a grievance. So what is the present status? That is what I mean.
Present
Nah,
status,
my instruction
after
was-
their period is over, I have to take instruction. What is the
So
Department
after your, it is now closed down as
No,
on
my
date.
period is up 25th of February. My period is January. It is extended time to that. But I was not able to collect it because there are some private party they are
25th of February
mailer up to.
up to.
lordship may kindly see the page number 15.
Where is your settlement?
prayer, my lord.
Earlier it was yes, like
So that you are saying that your term is till 25th
No,
of
that-
February. Where is that settlement?
up to that settlement is in after filing this sorry, Millard, after filing this petition Millard, that order is so I could not
That order?
I could not annex that. Sir.
That order?
That order is there. I
Show
am-
us.
At present Millard, I have no.
Then how that order has been issued in your favor?
From my side, Millard, if I say Millard, that is illegal.
This is an illegal. So
I admit Millard, what is
no,
illegal?
no.
I
So
could-
therefore,
but there is nobody there.
no. Let us understand. You are running a market by virtue of their blessings. We are
My-
not saying it illegal, isn't it? Without any tender process.
As because they are not. They are not reaching it.
We are not asking the reason.
Yes.
We are just understanding the fact. There is a cattle market. The market is under the Panchayat or something like that. Jila Parishad.
Jila-
Jila Parishad. They have not done any tender, something like that. They have given you the blessing to run the market. Now that blessing has in the meantime been withdrawn. And you have not been allowed to run. Though by virtue of that blessings, you are supposed to run till 25th of February. Now it's not being run. Now, therefore, you have become wise and now you think that this market should be settled through a tender process.
But I have come earlier, Millard, long back. It is in the month of October.
So therefore, as he has said, this has become infructuous. If any cause of action survives, you can come apace.
Up 25th February that I have clear order, Millard, but at present I have no. That is it.
We do not know because your prayer was something. What was your prayer?
My prayer, Millard, to demarcate the land and to issue
To NIT. But
We-
without demarcation
it's
of
not
the
a
land,
prayer.
without issuing NIT, they have ask you to run this market.
Yes.
You are running the market according to you.
And paragraph 5 Miller.
No, you are running the market according to till 25th. Isn't it? So it has become infructuous. After 25th, they may give you an extension. Isn't it? Or they
No.
may issue a tender. Either way, you are benefited. Either you want a tender or you want an illegal blessings.
Oh, I first I say Miller is illegal.
So therefore, we are closing this.
My submission Miller, first Miller, yes, I am also ready Miller for closing. But only Miller land should be demarcated.
So
And
that we are will not disputing. If the market, that market be settled in terms of the extent norms. If it is extent norms, they will have to demarcate the boundary. That is a must.
that is the problem, Miller.
In fact, my lord, their settlement,
They are not demarcated the land, Miller.
they were settled by
is
the
our
Jilla
problem,
Parishad.
Miller.
That was also illegal, man.
Who is to settle?
Anchalik Parishad is the main authority, man, to issue the NIT.
Mr. Sikdar, if you want us to enter into all this marriage, that may create difficulty
Yeah.
for you. Because if you argue, we will have to enter it. On the basis of your pleading. And there stand, you have filed affidavit.
No. No. And paragraph 5 Miller, please, I have also make my Miller that schedule of the land, Miller. Of page 7 Miller. There is the land schedule.
Please tell us, where is your order on the basis of which you claim that you should be allowed to December 2023?
Right.
Where is the order? There is a land dispute, is not it?
Land is
There is a civil suit.
my lord.
How can we direct that?
Civil suit now, that is also another history, Miller. Civil suit now become zero. Earlier there is a stay, now High Court has again, Miller, it maintained the express order. That also have an next year business.
Let this matter not be kept pending. Either in first class or on merit where it can be.
Page 24 is the order.
Page 24.
Annex 6. And page 15 is the prayer, my lord. It's up to 13/12/2023.
Subsequently, Miller, it is approved, but I could not collect the same, Miller. Another order, extension order is there up to 15/2, there is the but after 10 Miller again another order is Miller, that is I could not collect. It is Miller up to 15. Where it will last
15/2 is the subject matter of the next case, my lord.
15 to challenged by whom?
7496. Not challenge, my lord. Same prayer in the 7496.
Okay, let us see his settlement in this case.
Fine.
Page
Page,
24,
page,
24 kindly, Miller.
page 24. You have had the benefit of filing the writ. Is not it?
Actually, Miller,
You had the benefit of filing this
no,
pendency.
I have received nothing, Miller. As because I could not collect any revenue, Miller. Till date, Miller. Only on paper, Miller, I am Miller, they are as a lessee, but on fact, Miller, on physically, I am nowhere.
You are Mr.
Ajibur.
Azibur. Okay, what happened thereafter?
Then this is last but one. This is passed on 7/12 up to Miller 50. This is the last paragraph.
week. Hey. Today
Today is
Today is not, 20.
Huh?
March, February, my lord, 22.
anything out thereafter?
Thereafter, yes, up to 25th, again, my extension.
Lordship, the next item,
But
my
I
lord,
cannot
this is
calendar
the order to page 20, it is the same order.
No,
It is
no,
impugn in the next repetition.
No,
Not
Why?
impugn, that's settlement, my lord.
no,
No,
that
no.
is not there. This is not the, therefore, first, last sentence.
You want a tender? You want a tender?
Yes, yes.
We'll allowing this your
This
repetition.
one, page 22, my lord.
Yes, proceed with tender. What is the problem? From 2023, you are allowing an individual without any tender.
By Zilla Parishad, that is also illegal. my lord.
Whatsoever, who
It
is
more
the
than below
competent
1 lakh, so
authority?
Jila Parishad is the competent authority.
Who is the competent authority?
The video Ansarik
How?
Parishad.
No, that is only my 100 minute, 10 step.
Ansarik Parishad is the
Value more
competent
than 1
authority, my
lakh,
lord.
that is Jila Parishad.
That-
And
If,
less than 1 lakh, that is
if
my
it
Ansarik
value
Parishad.
exceeds 1 lakh, my lord, that is the sanctioning authority.
Whosoever competent will proceed in terms of the
Well,
Panchayat Act.
Yes,
What the hell?
Panchayat Act and in terms of the rule, what is settlement of
105.
105, section 105.
hard, Mr.
And only my one prayer will in between minute. Till the final.
We are not interfering
that
with this
cannot
till, not, no till,
How can man?
no till.
Then who will run in between minute? Then again.
That is their business, not our business, not your business. You want to continue.
my
One has you have coming that I am the savior of this
No,
system.
that is
I
not
want
my-
tender.
That is not.
And at the same time, from 2022, you are running on this pretext or that pretext. So you are closing it because you are a very good man. You want to have a
really
tender,
not
will
acceptable.
allow your repetition. Heard, Mr. Rashid, learned counsel for the petitioner. And Mr. Dr. learned standing counsel for Panchayat and Rural Development. And Mr. Bokolial
Man.
for G. Bokolial for respondent number 2. Mr. Rashid, learned counsel for the petitioner, has submitted that a cattle market named Satimari Posu Hat, Sataimari, CHATI, Sataimari Posu Hat, within bracket cattle market, was earlier run under the aegis of Jaleshwar Ansolik Panchayat. The grievance of the petitioner is limited to the extent that respondent Panchayat authorities have not undertaken any regular tender process for settlement of the said market named Satai Mari, settle market. Full stop. It is the further grievance of the petitioner that not that. Further grievance that the respondent number 7 and 8 are creating some problem as per running of the market. However, his basic grievance is that market should be settled through tender process in terms of rule and in terms of the
Section 105,
section 105 of the Panchayat Act
1994.
1995 and the rules
94.
and the rule 1994 and rules. What was the rule? Settlement of hard ghat, something was like that. And
The Assam Panchayat financial rules,
and under Assam Panchayat financial rules,
rules 47.
rules 1947.
No,
No, no,
rule
only
47.
40.
Oh, 47, rules 47,
Rule 47. Rules 2002, man.
rules 2002. Okay. Mr. Dr. Learned Standing Counsel for the department submits that the authorities under the Panchayat Act are under bounden duty to settle the market, hard, etc. in terms of the Act and the rules framed thereunder. And such rules and Act prescribes settlement of ghats, etc. through tender process. And therefore, the authorities under the Panchayat Act shall definitely settle the market through tender process. In view of such consensus, there shall not be any grievance left for the petition. Accordingly, the present full stop. It is also a fact that though no tender was issued, the market was temporarily settled, has been temporarily settled with the petitioner from time to time, and such period is this period is still valid till 25th of February 2024. First of all, in view of the aforesaid, this petition stands disposed of with the direction to the competent authorities under the Panchayat Act. Will not say
Yes.
under the act. Under the act to settle the market, settle the cattle market in terms of the Panchayat Act and the rules framed hereunder. Full stop.
One more aspect is,
Yeah.
may I submit, my lord? As this is a cattle market, my lord, the interference, the cattle act is also there, my lord, because the NOC will be given only by the deputy
That is
commissioner,
it. That is your business.
my lord,
But by virtue of cattle market,
my lord.
Market
will
Act,
not
you
go by
cannot
this,
take
yes,
out the right of a panchayat. It
My-
is the constitutional authority
My-
created under a special provision of the constitution.
243.
By a cattle act, you cannot take away the right. Cattle act for what purpose? How it's to be slaughtered, how
Yes.
it's to be sold, what should be the
There
condition?
is a provision, my lord, to run a cattle market. They have to collect one NOC from the deputy commissioner,
That is up to the panchayat,
my lord.
and that is under challenge, and
Right.
all likelihood that will go. You cannot, by way of an act, take away a right framed under us act. Cannot take away that right. Anyway, that is a subject matter of
My
a
lord.
division bench. We know that. I was a part of that.
My lord,
So we will not comment on this.
my lord.
Full stop. Market. Such exercise be carried out within a period of 3 weeks from today. Full stop.
Only the question of land demarcation, that problem.
That they will do. And if they give, continue to give you blessings thereafter, we are not here to say anything. Writ petition stands disposed of. And what about the next?
13 and 14 same, my lord. 14 and 15 same, my lord.
No, no.
13 and 14, my lord.
It is 13 your lordship passed order. 14 milord probably that is in practice or out of house with, and 15 milord in this similar I am the file milord in the I am I have filed caveat milord. Caveat is
Who are they? It is submitted by Mr. Who is for the petition? Non-APS MS Mr. You are Mr.
I'm-
Item 14.
14 milord.
14 infraction,
Huh?
infraction.
We have withdrawn our
Okay. It is
13
submitted by
14
Mr.
Yeah.
Sharma. T.R. Sharma, learned counsel for the petitioner, that they have withdrawn their wakalatnama from the brief from wakalatnama and accordingly intimated to the client through a registered post with AD which has duly been received. Therefore, they will not represent the petitioners today. Mr. Dr. Learned Standing Counsel submits that in view of the order passed in WPC 6-6-9-2023, nothing survives to be adjudicated in the present petition. Be that as it may, as none appears for the petitioner, as no one is represented, this matter petition stands dismissed for non-prosecution. Let us see.
Right.
Okay.
And
What about 15?
15 milord I have filed caveat, but there will be no copies are on me milord.
No, forget about that. No copy. What is the subject matter?
Subsidy milord same milord.
Same cattle market, they
market.
want
Tender. Huh?
No,
They
they
want
want to
tender, my lord.
continue the market.
They want direct settlement.
They are the-
Who is the counsel?
Because the already
S.U. Ahmed, none appears for the petitioner on call. This petition stands dismissed for non.
Right.
Interim order, if any, stands.
No,
vacant.
no interim.
Anyway, we have
Right.
given. Yes.
I love you.
No, admission. এটা রয়ে গেছে না? Mr. Sudhiri, wait for some time. Are you at us? Then we'll proceed, no? We'll take this method and proceed. Aru asil na eta admission? Then we'll go to here. Yes. Just summarize what are the issues.
The matter pertains to
Hmm.
renewal of a mining contract area.
Hmm.
There are two items, 3 and 4,
Hmm.
both pertain to the same mahal.
Hmm.
TD, the name. One is sand and one is stone, sand and stone.
Hmm.
Now, this is the second round of litigation. The petitioner, before your lordship,
What are the challenge here?
my
in this?
challenge, my challenge in short, is to the order.
We'll go details, but we just
Yes,
want to
yes,
understand
yes.
what is the challenge.
The impugn order dated 26/4/2022,
Hmm.
by which, my lord,
Hmm.
my prayer
Hmm.
for renewal of the mahal
Hmm.
was rejected.
Hmm.
Now, in short, my lord, the petitioner contends, my lord,
Hmm.
that the consideration, the grounds of rejecting my renewal application
Hmm.
is ultra virus, the rules 19 and 20, and the factors which has been considered are extraneous to the considerations which has been circumscribed by the Act. Now, the Act says, the rule says that this renewal application should be.
So according to you,
My lord.
renewal,
Yes.
when you are in a contract or a lease,
Yes.
continuation thereof should be determined within the parameter of
Exactly.
Rule 19 and 20.
Exactly.
And no other consider the prescription given therein
Yes.
can only be the consideration and not other thing.
Exactly.
This is your case.
Yes.
So let us see first Rule 9. Let us understand the facts first.
I'll become. Now, my lord, certain facts were the subject matter of the earlier litigation, but I'll just point it out just to give a, my lord, a perspective, my lord.
Hmm.
My lord,
So you obtained the lease after the first litigation.
lease was there. Thereafter, the lease was cancelled. I approached this honorable court.
Hmm.
The honorable court did not consider my grounds, but nonetheless, the honorable court, on the grounds of equity,
Hmm.
since I was not given the exact 7 years,
Hmm.
had given a liberty that I can apply for renewal,
Hmm.
which normally under the rule
Hmm.
should be done.
Okay, that gap period is
Period is
unknown.
controlled,
That
controlled.
because
Period
that renewal should be
Hmm.
initiation should be during the existence of the
Exactly,
contract.
18 months
18
prior
months,
the
prior to renewal. So in the earlier judgment, report says okay, fine, for this period we are
Exactly.
wiping out. Forget about that.
Yes.
So you take the other considered. So
Yes.
that ground is no more.
Exactly. Now the story begins from the judgment, my lord.
Hmm.
The judgment, I'll take my lord to the judgment, my lord. What
Hmm.
does the judgment say?
Hmm.
My lord, the judgment and order, my lord, 84 to 109.
Hmm.
It's a bit longish,
Hmm.
but my lord, lordship would directly come to page 108, my lord. Okay, 329. 108, my lord.
108.
My lord, lordship is taking up WPC 3295, my lord. I'm referring
We are
to.
taking 3 to 7 one.
I'm so sorry, my lord. May I kindly take up the other same annexure. 3295. Page 108, my lord.
Is
108, paragraph is 28. Second paragraph.
paragraph is 108.
Eight. Paragraph
Paragraph
28. May I read?
just a minute. 108. Yes, paragraph is
28. That in view of the matter, the court for the ends of justice on the peculiar facts of the case permits the petitioner to file application seeking renewal of the contract agreement dated 1/9/2014 in respect of contract pertaining to two writ petitions by waiving the period of 18 months as required under Rule 19(1) of the Rule of 2013.
Hmm.
The said application shall be filed within a period of 20 days from the date of instant judgment, and the competent authority shall consider the applications for renewal within the parameters, I'll got to take note,
within the parameters prescribed under Rule 19 and 20 of the Rules of 2013. It is further directed that till disposal of the applications for renewal, the tenders so issued as impugned in WPC so and proposed to be issued in respect of the area being the subject matter of WPC 921 shall not be given effect. Thereafter, my lord, with the above observations, both the writ petitions can be disposed. Now, my lord, would come to my application. Sir. Next page, 110. The representation pursuant to the judge. Page 110, my lord. Subject, a prayer for renewal of mining contract for the following mining unit as per Rule 19 of the AMMP Rule 2013 and in compliance of the common judgment and order dated so and so. The 2 units, my lord, stand and stone. My lord would turn the page and my lord would come to page 113, my lord. What the petitioner has stated. 113, paragraph 7. Page 113. Sorry. That in view of the aforesaid direction issued by the Honorable Court, the undersigned has filed the present representation. The undersigned, along with the present application, has attached the duly filled statutory MC2 form seeking renewal of the mining contract for a period of 5 years in terms of Rule 19 of the 2013 rule. It is stated herein that the undersigned has never violated any terms and conditions of the mining contract and have never defaulted in payment of rent, kist, etc. The undersigned submits that the undersigned fulfills all prerequisites prescribed under Rule 19 of 2013. That in view of the so and so, the last 3 lines. However, if anything, including documents, clarification, etc.
Where?
The last paragraph, the second last paragraph on the page. I'm not reading the entire paragraph.
Okay.
However, if anything else, including documents, clarification, etc., is desired by your good self, the same may be notified to the undersigned. Now, by way of the representation, my lord, first I submit the statutory form, which is required to be submitted as per law. Thereafter, I also state that I fulfill all the terms and conditions, and I also say that if anything is left, you for any clarification is required, I'm ready to give such clarification. Now, my lord would come to page 115, my lord. Before the impugn order was communicated, on 29/4/2022, they issued the tender for my Mohal, both the Mohal. And after seeing this, my lord, I come to know about the impugn order, which is at page 1117. I'll read it out, my lord.
Yes.
Peruse the Honorable High Court order of so and so versus so and so, wherein the petitioner was permitted to file application seeking renewal of contract in respect of the contract pertaining to two petitions by waiving 18 months as required under so and so. The said application shall be filed within a period of 20 days from the date of the instant judgment. The competent authority shall consider the application for renewal within the parameters. They acknowledge that fact, my lord, prescribed under Rule 19 and 20 of the rule of 2013. My lord will turn the pages and directly come to the conclusion. My lord will come to page, my lord, 119, the last paragraph. During the course of hearing, depending on peculiarity of the case wherein petitioner was permitted to file application seeking renewal of contract agreement dated so and so in respect of the contract pertaining to the two writ petitions by waiving the period of 18 months under rule so and so, it was exclusively decided to seek report from the Chief Conservator of Forest, Southern Assam Circle, Silchar, whether the MCA should be renewed, keeping in view the revenue aspect of the government exchequer, since the MCA were originally settled long back in the year 2014. Now, my lord, at this juncture only, I would like to point out one thing, my lord. This renewal, my lord, that discretion has to be arrived at by the competent authority. Now, the competent authority is not the chief conservator, of forest, but the head of the forest department. Now, my lord, lordship would see clearly that decision whether to renew or not renew was not taken by the competent authority as per law, but he forwards it to his junior and he says, you take a decision, you let me know. Subsequently, the paragraph 5 I'm reading, my lord. Subsequently, the chief conservator of forest, Southern Assam Circle, Silchar, has submitted his report by his letter number so and so, wherein he has clearly mentioned that Chiri and Chiri NCA Sand 2 will bring more government revenue if both the MCA is put on fresh sale, considering the availability of minor mineral, revision of schedule of royalty, market trend, instead of renewal of the same by increase by additional amount of rupees 25% over the amount of contract money payable in the last year of the original contract.
Let us see rule 19 and
Yes.
20.
My lord has taken
But we will not get back if we continue with this
Lord
hearing.
will keep 9 also.
Rule?
Rule 19 and 20, my lord.
Well, we have 1 second here.
Okay.
19, my lord. 7 is important. Renewal of mining contract, my lord, could directly come to 19.7. A contract for minor minerals granted under Rule 18 may be renewed only once by the competent authority for a period not exceeding 5 years, and after having satisfied itself that the contractor has undertaken mining operation strictly in accordance with the terms and conditions of the grant, contract agreement, and other approvals, permissions for mining granted by the central state agency. Now, my lord, to see from 7, my lord, it says there is a discretion on the competent authority that he may, it uses the word may. Therefore, my lordship, I'll come to that, my lord, later. Whether that may mean shall, I'll come to that, my lord. But there is a power which has been conferred, which is apparent from, my lord. How
So
does-
your whole case is that this is not relevant here, whether this power is may or shall. What relevant here is, even you have failed to exercise the power in terms of the rule 7.
Yes,
That's all.
yes.
Now, so therefore, matter is to be remanded back.
No.
No, that is his argument. Mr. Gogoi, don't be
My man.
excited. Don't be excited. Huh?
Now,
Don't
the
be excited.
third, Rule 19.7
Hmm.
confers a discretion on the competent authority.
Hmm.
Now,
And they are
yes.
to exercise their discretion in a prescribed manner.
Manner. And what-
According to you, that as per that prescribed manner, this
Yes.
discretion has not been
Yes. So what is the
exercised.
manner, my
So
lord?
therefore, this is a exercise of jurisdiction, not as per law.
That exactly, my lord. That may, my lord, that
Hmm.
discretion. It's not like any unfettered discretion, like a private person.
Uh,
I give my will to anyone I like. I cannot do that. I'm a public servant.
No,
And
his
that is-
argument will be that whether we renew or not renew
Hmm.
is our discretion.
Exactly.
But when we decide to renew, we can renew on this parameter. Number 1. And number 2 is that maximum once and maximum period is 5 years.
Yes,
So
that
3
is-
conditions. One is 1 year, 5 years, maximum period, only once.
Yes.
Second, and third is that even if we think that it should be extended, this satisfaction should be that you have not violated the terms and condition of grant, contract agreement, or other approval, permission, mining granted by state.
Yes. And that is, my lord. It has been specifically said in 20. Lord, to put term
Ah.
20. Decision on the application for renewal of mining.
Okay.
So, my lord, the discretion is not absolute. It
Hmm.
has been circumscribed by 20. It says
Okay.
the application for renewal
Hmm.
of a mining contract shall be decided on satisfaction of the competent authority with regard to the following. Number 1,
Hmm.
the contractor has complied with all the terms and conditions of the contract agreement and other permissions for undertaking the mining operations. The mining operations under original contract grant have been carried out in a scientific manner. The mined out area has been restored, reclaimed, rehabilitated, so and so. The contractor has not been in default of submission of any returns with regard to production, payment, contract money, so and so. The contractor has not been penalized in any manner, including suspension of mining contract, so and so. Substantial investment has been made by the contractor, so and so, with a long-term perspective, and the same could not have been derived during original contract period, so and so. And 7, my lord, which is important,
Hmm.
such other matters as may be considered. Now, here's this thing, my lord. Now, what they are saying, my lord, that the consideration that it would bring out more revenue, although it is not specifically there in 1 to 6, but we have exercise powers under 27, which says such other matters as may be considered. Now, my lord, one thing in jurisprudence is very clear, my lord. So there is a principle called adjustum generis, my lord.
Hmm.
So adjustum generis, my lord, in my humble understanding, it means, my lord, when there are certain specific words which is followed by a general word, like in the instant case, my lord would see from 21 to 6, it speaks about the conduct of the contractor during his earlier period. Lordship may kindly read it again to satisfy your lordship, my lord.
Yes, yes, I've read.
It pertains to the conduct. Now, when it says such other matters as may be considered, that phrase such other should be considered adjustum generis, although such other is very wide. But as per interpretation, my lord, it has to be restricted within the other enumerated items, my lord. Well, it cannot be like chalk and cheese, my lord. It has to be something related to the conduct of the party. Now, my lord, one important feature, aspect, my lord. Now they say on a hypothetical report that if we tender it, we will fetch a higher price. That is their contention. Now, my first argument, it does not fall within the four squares of 19.7 or 20. And further, that aspect itself of fetching revenue has been taken care of by the rule. My lord would come to 23, my lord. 20 subclause 3, my lord. Where the competent authority accords its approval to the renewal of a contract, the annual contract amount shall be increased by an amount of 25% over the amount of contract payable in the last year of the original contract. So the last kiss money, what I was paying, if it is renewed on fulfillment of the rules 21, I have to pay a 25% extra on the last kiss money. So, my lord, in my humble submission, that aspect of generating revenue has already been considered by the rule. Now, I would like to place certain judgments. My lord, may I use iPad?
Yes, yes. That is now a part of life. Hopefully, for Mr. Chaudhary, hopefully within 3 to 4 months, some of the courts will be, at least 6 courts will be paperless.
Save a lot of paper.
Then all of you will have only skin. All of you will have, we will have the same skin.
We have to approach for EMI.
Huh?
Approach for EMI.
No, you need not. We are giving the skins here. Have you seen in the cost list that you click a link, it comes. Now that link, you will have everything in your screen from the affidavit to orders. So you will just read it. There will be an index.
Just give me 1
This is
minute.
for Mr. Chaudhary, NNB. Yes.
I'll just give me 10 seconds.
Yes,
I'm
yes.
also new to. No, you can thank. My lord, I'll first place the judgment regarding when may should be considered as shall and when. This is 1977 2 SCC 166.
1977,
2 SCC
2 SCC,
166.
166.
Okay. Hello, paragraph 7, my lord. I've marked it. I'm sorry, my lord.
No issue. That helps us.
My lord.
Paragraph 7.
Paragraph 7.
Just a minute. We are coming.
We read together. It is only when there is the object of the two sections when read together is served by a stay order. The object is to expeditiously decide. My lord, directly come, my lord,
In the words.
in the word. It, it follows that the order to be passed must be discretionary. The power to pass.
Just a minute. Just a minute. Mm, Where? It follows. Okay.
It follows.
Hmm.
It follows that the order to be passed must be discretionary, and the power to pass it must therefore be directory or and not mandatory.
Hmm.
In other words, the word may used before stay in section 442 of the Act really means may or not must or shall in such a context. In fact, it is not quite accurate to say that the word may by itself acquires the meaning of must or shall sometimes. The word, however, always signifies a conferment of power. The power may, having regard to the context in which it occurred and the requirements contemplated for its exercise, have annexed to it an obligation which compels its exercise in a certain way on facts and circumstances from which the obligation to exercise it in that way arises. In other words, it is the context which can attach the obligation to the power compelling in its exercise in a certain way. The context, both legal and factual, may impart to the power that obligatoriness. Thus, the question to be determined in such cases is whether the power conferred by the word may has annexed to it an obligation that on fulfillment of certain legally prescribed conditions to be shown by evidence, a particular kind of order must be made. If the statute leaves no room for discretion, the power has to be exercised in the manner indicated by the legal provisions which provide the legal context. Even then, the facts must establish that the legal conditions are fulfilled. A power is exercised even when the court rejects an application to exercise it. It is the particular way in which the applicant desires it to be exercised. When the power is wide enough to cover both an acceptance or a refusal, an application for its exercise, depending upon fact, it is directory or discretionary. It is not the conferment of a power which the word may indicate that annexes any obligation to its exercise, but the legal and factual context of it. As we understand it, was the principle laid down in the case cited before, so-and-so, the Hilda Julius versus Right Reverend Lord Bishop Sutton. Dr. Julius, in the case mentioned above, had made an application to the Bishop of Oxford against the rector of a parish, asking the bishop to issue a commission under the Church Discipline Act to inquire against certain unauthorized deviations from the ritual in a church by the rector. The relevant statute merely conferred a power by laying down that it shall be lawful to issue a commission. The courts of Queen's Bench and of appeal in England had differed on the question whether a mandamus from the court could go to the bishop, commanding him to issue a commission for the purpose of making the inquiry. The House of Lords held that the power to issue commission was not coupled with a duty to exercise it in every case. Although there may be cases where duties towards the members of the public to exercise a power may also be coupled with a duty to exercise it in a particular way on fulfillment of certain specified conditions. The statute considered that there had not specified those conditions. Hence, it was the bare power to issue or not to issue the commission.
Your whole case is this line.
Yes, yes.
Let me read it.
Yes.
If the condition in which the power is to be exercised in a particular cases are also specified by a statute, then On the fulfillment of those conditions, the power conferred becomes annexed with the duty to exercise it in that manner. This is the sum and
Exactly,
substance your
exactly,
argument,
exactly, my lord.
isn't it?
Exactly. I won't read.
You want to say that this is the way the statute and made a prescription to exercise a power.
Yes.
So therefore, since statute is so specific for
Well-
exercise, that may becomes
Yes.
obligatory
Right.
to exercise that power once an application is given. That is your
Yes.
argument.
Now,
So there cannot be a question that I will not even, according to you, I will not even consider those issues, because the may will mean that I may consider those conditions
Mm.
or I may not consider those conditions.
Yes.
So your case is when a specific prescription is given by the statute itself, you are under bounden duty when an application is filed to, you must consider my case in terms of that prescription.
exactly. And my lord, if that is not done, what happens? I won't trouble your lordship.
No, you must trouble. Then only we can pass a proper judgment.
What had happened, my lord? I saved all the judgments in the iPad. This is the difficulty of being technical.
Hmm.
I opened it in front of them. I opened the folder, Joydeep Wala. Everything is vanished. I don't know how it happened. my lord.
That is still there.
It is still there, maybe because of the internet. I don't know, but I'm everything, my lord, I've prepared.
No,
for.
you do one thing. You find a source by the name of the file. That will come. This is iPad or what?
iPad.
You just search it.
Not safe for it,
No,
not
I-
for it.
You will get it. Anyway, and then what are
And
the
Barium Chemicals, my lord. Barium Chemicals says, my lord, 5 judges,
Hmm.
Justice Hidayatullah and Taylor, not to put, I'll give the exact paragraph, my lord. Hidayatullah says if the grounds are specified and there is a consideration
Hmm.
which is extraneous to the rules or the act,
Hmm.
it will be irrelevant, it will be void ab initio. It will be,
give that judgment?
my lord, AIR 1967 SC,
Year 1967
SC
SC
295,
295
Barium Chemicals versus
paragraph.
paragraphs. It's a 5 judges. I'll give the paragraph which was there. I'll give it.
Okay.
So next, my lord, what my lord has considered
Hmm.
is the fact whether, my lord,
Hmm.
the provision which says such other,
Hmm.
that is the main contention on facts, my lord.
Hmm.
Whether such other would also include fetching more revenue. Yes.
Yes.
Then Lord could kindly peruse the principles of my lord, 2008 for SCC 584.
2008
84
4
SCC
SCC
584.
584. Paragraph, any paragraph?
Yes, my lord. Paragraph 9. Well, read paragraph 9.
Hmm.
The provision of labeling of edible oil
Hmm.
and fats is under Rule 37D of the PFA rule, which specifies labeling of edible oil and fat.
Hmm.
The rule clearly states that the package labeling or advertisement of edible oil and fat shall not use the expression such as super refined, extra refined, micro refined, double refined, ultra refined, anti-cholesterol, cholesterol fighter, soothing to heart, cholesterol friendly, saturated fat free, etc. It would be pertinent to say that all these expressions from 1 to 9 are prohibited because they are mentioning on the labeling of the product that they will tend to exaggerate the quality of the food. The rule further states that all such other expressions, my lord, that all such other expressions are also prohibited, which tend to exaggerate the quality of the product. For the purposes of interpretation of this rule, the principle of adjustum generis can be applied. Adjustum generis is a Latin expression which means of the same kind. For example, where a law lists specific classes of persons or things and then refers to them in general, the general statements only apply to the same kinds of persons or things specifically listed. In other words, it means words of similar class, according to Black's Law Dictionary, the principle adjustum generis.
The ratio is this.
Yes.
It is a canon of statutory construction that
Yes.
where general words follow the enumeration of
Yes.
particular clauses of things,
Yes, madam.
the general words will be construed as applying only to
Yes.
things of same general class as those enumerated.
Yes, yes,
Therefore, in this case, according to you,
yes, ma'am.
the enumeration
Yes.
under rule
21,
under rule 21 to
Roman 1,
Roman 1 to Roman 6 necessarily include anything close to those 1 to 7, more particularly for the reason that clause 3 has covered under its fold the enhancement of
revenue.
revenue.
Right.
The protection of revenue is taken care by the rule 3. That is your argument?
Yes, yes.
Okay.
And if my lord reads the enumerations 1 to 6,
Hmm.
what I could gather, my lord, is
Hmm.
subject to what my lord says.
Hmm.
But all these, lordship would see, lordship reads it again.
You will see that this basically relates to the
Conduct.
past conduct of the lessee or lessee
Yes.
during his
Earlier.
earlier.
Relevant, my lord, because I have my thing is to be renewed.
Hmm.
So these are the relevant consideration because the consideration with regard to money
Hmm.
has already been taken care of.
Okay.
Now, one more adjustum generis, my lord.
Yes.
This is my lord.
All right.
I have pointed everything, but I'll just use one title.
No, I am saying that his judgments you are having in your hand.
Yes, because my lord, I have clarified what he has done. I need not, my lord, see,
Okay.
post my lord, see what he is trying to
Okay.
convey. My lord. The specific word is written there.
Okay. Then this is the judgment.
Yes.
Yes. Which paragraph?
My lord would come to
Just a minute.
paragraph 17. The
This
last
is just let me note it down. Paragraph.
paragraph 17, my lord. The last paragraph, it begins from in Siddheshwari Cotton Mills versus Union of India.
Just a minute. Paragraph 7.
17, my lord. 17, the last part of no paragraph 18, my lord. The second subparagraph of 18. The first subparagraph of
18. Put the period of service.
yes.
It starts with that.
The next paragraph.
Hmm.
The next subparagraph.
In Siddheshwari.
Yes. In Siddheshwari Cotton Mills versus Union of India, the Supreme Court, while discussing the definition of manufacture under 2F of the Central Excise and Salt Act 1944, whether the relevant process fall within any other process, thereby within the provisions of 2F5 of the court looked at the meaning of the expression adjustum generis, which means of the same kind or nature, signifies a principle of construction whereby words in a statute which are otherwise wide but are associated in the text with more limited words are by implication given a restricted operation and are limited to matters of the same class or genus as preceding them.
Hmm.
If a list or string of family or of genus describing terms is followed by a wider or residuary or sweeping up word, the verbal context and the linguistic implications of the preceding words limit the scope of such word. The court also discussed various other texts while looking at them. In statutory interpretation, Rupert Cross, my lord, Lordship may also quote this.
Hmm.
If Lordship desires, I'll read it. Otherwise,
No, no, no.
this is one more. Now, my lord, another aspect, my lord, to consider.
Hmm.
My lord, I'm also handing over, my lord, the 3 copies, my lord, at market.
Hmm.
These are the lexicons, Ramanatha Iyer, meaning of touch, Black Law Dictionary, meaning of touch,
Hmm.
and principles of statutory interpretation by
Hmm.
Now, coming to one other point, my lord.
Hmm.
Lordship has seen the impugn order, my lord.
Hmm.
An admitted fact, the competent authority to decide renewal is the PCCF. Now, while the application is made to the PCCF deciding it on its merit by using his own discretion had forwarded the application to a person who was not authorized by law to decide it. And without applying his own discretion,
Hmm.
he has acted as a post office and accepted what has been reported by his junior. In that case, my lord,
Hmm.
if it is not exercised by a person
Hmm.
on whom jurisdiction is vested by law, the entire impugn order becomes null. To put forth that argument, Govardhan Das Bhanji, I'll just hand over the copy and the patent. Hello, Govardhan Das Bhanji, AIR 1952. The paragraphs are, my lord, the ratio is at paragraph 56.
$57.
Or paragraph 47. 47, I'll just read out the famous lines, my lord. 47, well, within inverted commas, there may be something in the nature, my lord, has it been quoted in paragraph 47 last.
There may be.
Yes. There may be something in the nature of thing empowered to be done, something in the object for which it is to be done, something in the conditions under which it is to be done, something in the title of the person or person for whose benefit the power is to be exercised, which may couple the power with a duty and make it the duty of the person in whom the power is reposed to exercise that power when called upon to do.
Hmm.
So he is that person, PCCF. Admittedly, he did not decide. Now coming to the
Suppose, will he not have a power?
Yes.
If we go by your whole argument, will he have not a power to collect certain evidence?
Yes, exactly.
Collect certain evidence through his junior officer so far relating to clause 20 from 1 to 7.
Hmm.
He might have arrive at the satisfaction whether you're to know about your conduct. Can't he have an report from his junior that give me this report because I am considering an application
Yes.
for renewal?
Obviously, that power is vested on him, but it
He has
to,
exercised that. He has
Yes,
brought the report
but it
from
has
the
to
official.
appear from the impugn
And he
order.
had the satisfaction on the okay, fine. For the time being, even if we agree with your argument for the time being, as you are arguing, that these are the parameters that
Hmm.
ought to have been exercised.
Hmm.
And but to exercise that power, he can very well bring to his
Yes.
satisfaction that whether these are satisfied.
Yes.
Or do you expect the adjudicating authority to collect the data from the field? That will we go to that extent?
Just my argument, my
Okay,
lord.
that's fine.
my last limb of argument anyway. That's the weakest.
Okay.
But nonetheless, I have argued.
Okay.
That's my duty to argue. Okay. My lord, coming to the last point, my lord.
Hmm.
Now, I have prayed for passing writ of mandamus.
Hmm. For
Now,
renewal.
mandamus to
Hmm.
renew the
Hmm.
contract. Now, what happens, my lord, in a situation where there is already a direction by the Honorable Court
Hmm.
that you consider an application in such terms and conditions? the rule 19. Even after the specific direction, if that is not complied with, can the court pass an order which ought to have been passed by the competent authority? Can that be done? Because that's my argument. In case my argument is
Okay.
considered, other points are considered.
So suppose we are satisfied that yes,
Yes.
these
What-
parameters are next. Now next question will be
What
what
are the-
relief?
Yes, what relief?
So according to you, we should even pass a direction for renewal.
Renewal.
Okay.
Hello.
So you then will have to have a satisfaction that all these parameters
Yes.
are fulfilled. These are not before us.
To argue, to reply to that, my
Hmm.
lord, I have filed my writ petition, I have filed the representation. They have not mentioned a single word in their affidavit or a reply to the representation that I have violated any of those. Because I know as a prudent businessman, my lord, everything has been complied with. Otherwise, they would have got that opportunity also because that was not there. They have come up with this alien consideration. Now, as I'm referring to one judgment, my lord,
Hmm.
Hare Krishna Mandir Trust versus State of Maharashtra.
Give the citation.
Citation to put
2029 SCC 359
2029
SCC
SCC.
356.
Okay, read it.
Yeah, I'll read it.
Paragraph 9.
Paragraph.
Paragraph?
I'll just bring the paragraph. Yes. I'll read it slowly. Lordship has
No, you read it. You read it. We'll have the book is coming.
the High Court exercising their jurisdiction under Article 26 of the Constitution of India.
Paragraph, what do you say paragraph?
100.
Hmm.
The High Court exercising their jurisdiction under Article 226 of the Constitution of India not only have the power to issue a writ of mandamus or in the nature of mandamus, but they are duty bound to exercise such power where the government or a public authority has failed to exercise or has wrongly exercised discretion conferred upon it by a statute or a rule or a policy decision of the government, or has exercised such discretion mala fide or on irrelevant grounds. In all such cases, the High Court must issue a writ of mandamus and give directions to compel performance in an appropriate and lawful manner of the discretion conferred upon the government or a public authority. Paragraph 102. In appropriate cases, in order to prevent injustice to the parties, the court may itself pass an order or give directions which the government or the public authorities should have had it properly and lawfully exercised it. So, my lord, the court in certain circumstances can exercise that power.
We have the power,
Yes.
but whether this is
Yes.
a fit case to be
Yes,
exercised,
that your lordship.
that is left.
That your
Yes.
lordship.
Having power and exercising is
Yes.
the two different. Anyway, yes. That's all.
That's all, my lord.
Anything more?
I remember I just got my lord.
Okay, we can you can
I'll
read.
reply after my learned.
Yes. Very yes, binder. Unniversal binder. Yes, go ahead.
My lord, the many full arguments have come. My lord, will kindly take up the affidavit in reply filed by the petitioner in 3271.
3271.
71.
Which
The
we are
entire matter is this time.
okay.
Entire matter. He has replied that he has applied adjustum generis, so we cannot have our own consideration which is independent.
Okay, paragraph, a reply affidavit.
Reply affidavit.
Just a minute. Page,
Paragraph 9, my lord,
page,
137.
page,
137, my lord.
one.
Paragraph 9, my lord. That is his case. Shall I read my?
Yes.
The statement made in so and so paragraph, it's stated herein that a receipt of extra revenue cannot be in any stretch of imagination be construed as such other matters occurring in Rule 21
Hmm.
7. Applying the principle of adjustum generis, Rule 21 8, which provides for such other matters, or my lord, this should have been 7. Somehow 7 only.
Mhm.
Would have only take with it all conditions which pertain to the conduct of the contract holder during the last settlement. The contention raised by the respondent authorities in the paragraphs under reply doesn't hold any water.
Hmm.
So he says, my lord, motive the rules for a moment.
Hmm.
The contention the petitioner is
Hmm.
that Rule 21,
Hmm.
those rules are 1 to 6. They have
Rule
Rule 20,
20.
sub Rule 1,
Hmm.
sub therein 1 to 6.
Hmm.
They form a, there is, my lord, there is ambiguity in the rules. So, my lord, there is ambiguity, and this form a genus,
Hmm.
and that 7 is also a part of the genus.
Hmm.
That is his case.
Hmm.
We cannot go beyond that,
Hmm.
he says. But, my lord, the most interestingly, my lord, Rule 6, my lord, Perus, substantial investment has been made by the contractor in the development of mine and plant and machinery with a long-term perspective and optimal benefit of the same. Could not have been derived during the original contract. And, my lord, there is an and used.
Hmm.
And is used.
Hmm.
So my argument is, my lord, when the and is used, my lord, the principle of this adjustum generis doesn't come to play. Because, my lord, the n is used preceding to that 7. Any such matters as may be considered. So n, when n is there, my lord, it is disjunctive and it creates own class of its own. When there is no ambiguity, when this intention of the legislation is specifically clear that we intend to create a separate class itself by using the word intent, n, my lord. For that, my lord, I'll rely on, I'll give a book list also.
Hmm.
It's 2000, all the, well, I like to point out, all the judgments he pointed, my lord, for 2008 regarding this adjustum generis. Well, I'm using 2010.
Hmm.
Book list is 2010.
2010 3
3 SCC 786.
3 SCC 7 paragraph
786. My paragraphs I'm coming.
Okay,
Maharashtra University of Health.
paragraph
See, my lord, paragraph 6 or 16, my lord. 16. Herein, my lord, the main question on which the matter was argued by the appellants was the High Court was in error in deciding the grievance committee constituted under Section 53 of the SAID Act has no jurisdiction to take cognizance of any complaint filed by the 5th and 6th respondents, as they are not approved readers of the respondent college. In order to appreciate the legal issues involved in this argument, it is better to set out definition of teacher under Section 235 of the SAID Act. 17, my lord. Section so and so 2 says, my lord, teachers mean full-time approved demonstrators, tutors, assistant lecturers, readers, associate professors, and other persons teaching or giving instruction on full-time basis in affiliated college or approved institutions in university. Paragraph 15, Section 53 of the SAID Act provides, there shall be a grievances committee in the university to deal with the grievances of the teachers and other employees of the universities, colleges, institutions, and other recognized institutions, and to hear and settle grievances as may be practicable within 6 months. I'll skip a part. My lord, the construing paragraph 19, construing the aforesaid two decisions, the two sections, the High Court, following the principle of adjustum generis, held that 5th and 6th respondents being unapproved teachers do not come within the definition of teachers under the section 235 quoted above. Well, since n was used and other persons, the Honorable High Court held adjustum generis. So it's a spaces, one genus covers all, so you are not teachers. In that, this court cannot accept the aforesaid decision of the High Court for various reasons indicated hereinafter. In the definition of teachers, as quoted above, is properly perused. If properly perused, it would appear that within the definition of teachers, not only full-time approved demonstrators, tutors, assistant lecturers, etc. are included, but the definition is wide enough to include and other persons teaching or giving instruction on full-time basis in affiliated college or approved institutions in the university. Similarly, the grievance committee, which is established under Section 53 of the said Act, has also been given wide powers to deal with not only the grievance of teachers, but also the other employees of the university, colleges, institution, and to frame the grievances. 22. On a combined reading of Section 235 with Section 53 of the said Act, this court is of the opinion that in respect of unapproved teachers, also the grievance committee has the jurisdiction. Section 20, paragraph 23. The definition of teachers under Section 2 sub 35 is wide enough to include even unapproved teachers. In fact, the said definition has two parts. The first deals with full-time approved demonstrators, tutors, assistant lecturers, etc. And the second part deals with other persons teaching or giving instruction on full-time basis in affiliated college or approved institutions in university. Even though the approved teachers and those other persons who are teaching and giving instruction fall in two different classes, both are encompassed in the definition of teacher under Section 2 sub 35, and the word and before other person is disjunctive and indicates a different class of people. A class is a conceptual creation taking within its whole numerous categories of person within similar characteristics. Herein, in the group of other persons following those who on full time basis are teaching or giving instruction in college affiliated university, and they are also teachers even if they are unapproved. Para 27. The Latin expression adjustum generis, which means of the same kind of nature as a principle of construction, meaning thereby when general words in a statutory text are flanked by restricted words, and the meaning of the general word are to be restricted by implication with the meaning of the restricted word. This is the principle which arises from linguistic implication by which words having literally a wide meaning are treated as reduced in scope of verbal context. It may be regarded as an instance of epilepsy or reliance on implication. This principle is presumed to apply unless there is some contrary indication. Well, in this case, I'll pause for a moment. In this, this N indicates that there is a contrary, it creates a separate class itself, and indication is clear. This adjustum generis principle is a facet of the principle of nocitur est soci. The Latin maximum nocitur est soci contemplates that statutory term is recognized by its associated word. The Latin word socis means society. Therefore, when general words are just type of with specific words, general words cannot be read in isolation. They are color and other contents to be derived from their context. But like all other linguistic canons of construction, the adjustum generis principle only lies when a contrary intention does not appear. In the instant case, a contrary intention is clearly indicated, inasmuch as the definition of teachers under 2 sub 35 of the said Act, as pointed out above, is in two parts. The first part deals with the enumerated categories, but the second part, which begins by the expression and other, emphasizes a different category of person, and here and is disjunctive, and so while considering such a definition, the principle of adjustum generis cannot be applied.
Okay.
Well, lot of I will not trouble with this. And the other limb, Lordship had addressed that part, that the order impugn. PCCF is not the authority. My Lord, he has endorsed. Normally, my Lord, when a chief secretary calls for a report, my Lord, TC has to go. It is not that he has to visit. It is not his case, my Lord. And that apart, my Lords, I think it's 2013, 6 SCC 573, Kandanath Distilleries, State of Kerala, Kannada. Here I will deal with.
This is as regards?
This is as regards the mandamus to be, how to be exercised and how mandamus does discretion and mandamus, my Lord.
Okay.
So paragraph, my Lord. 28, my Lord. Discretion and duty, man. 28. And discretionary powers, 28. Discretionary powers implies freedom of choice. A competent authority may decide whether or not to act. The legal concept of discretion implies power to make a choice between alternative courses of action. The statute has conferred discretionary power on the commission and the state government, but not discretion coupled with duty, because they're dealing with a subject matter on which state has a legislative privilege. Here I'll pause, my Lord. My Lord, this is alcohol. The subject my lord is reading. This is alcohol, and the subject we're dealing is minor minerals. It's a settled proposition, my lord. In minor minerals, there is no fundamental right. It is also rest extra commercial. So this fits my case. Permissive language used by statute in section 14 and the rulemaking authority in rule 4 gives the state government and commissioner no mandatory duty or obligation to grant license except perhaps to consider the application if the liquor policy permits so. 29 my lord, section 14 uses the expression commissioner may with the approval of the government. So also rule 4 uses the expression commissioner may if he is satisfied after making such inquiries as he may consider license may be issued. All those expressions used in section 4 and 14 confer discretionary power on the commissioner as well as state government. Noted discretionary power are coupled with duty. The powers conferred on the commissioner as well as the government have to be understood in light of the constitutional scheme, bearing in mind the fact the trade or business which is inherently harmful can be restricted, curtailed, or prohibited. Well, I will not say harmful, but here it is curtailed and restricted. Since it is the exclusive privilege of the state, no duty therefore is cast on the commissioner to grant a license for establishing a distillery unit, and no right is conferred upon any citizen to claim it as a matter of right. The state can always adopt a restrictive policy, so in similar to reducing, example is reducing the number of licenses. I'll skip my mandamus to issue license. The legislature, paragraph 30, the legislature, when confers a discretionary power and authority, it has to be exercised by it in its discretion. The decision ought to be that of the authority concerned and not that of the court. The court would not interfere with or probe into merits of the decision made by an authority in exercise of the discretion. The court cannot impede the exercise of discretion of an authority acting under statute by issuance of a writ of mandamus. A writ of a mandamus can be issued in favor of an applicant who establishes legal right in himself and issued against an authority which is a legal duty to perform. So, my lord, before issuing the writ of mandamus, I'll skip the High Court should have at the back of its mind the legislative scheme, its object and purpose, and the subject matter, my lord. So,
Okay.
that is my lord. And another one I'll put up. Oh,
What is the, yes,
yes, my lord. 2000. Yeah.
2000,
Well, 2012, 10 SCC 1,
2012 10 SCC, page 1.
page 1. my lord.
Yes.
So this is a case where it goes to reference under the spectrum case, 2G spectrum. I'll just read
Paragraph
paragraph 156,
156,
186, 187, and 188.
156, 186,
187 and 180.
and
188.
188.
180. And 156, if my lord has. Can you feel it? Is it idea? No? No, 12 to
12 is here with me.
56.
Just a minute. One 56. Yes.
Well, the petitioner herein is a private individual. The resources are natural resources which a state is a guardian. So when you are giving away to him to exploit, my lord, the only consideration is, my lord, maximization of revenue. So, my lord, this paragraph, my lord, indicates.
Okay.
Well, before venturing into the area of consideration expressed in the foregoing paragraph, it is necessary to record that there was extensive debate during the course of hearing on whether maximization of revenue must be all the sole permissible consideration for disposal of all natural resources across all sectors and in all circumstances. During the course of this debate, the learned Attorney General for India acknowledged that auction by way of competitive bidding was certainly an indisputable means by which maximization of revenue returns is assured. If it is not as if one would like to bind the learned Attorney General to the acquised proposition, during the course of the days and weeks of erudite debate, the learned counsel emphasized the disposal of assets by process of tender come auction, and auction could assure maximization of revenue returns. Of course, there are a large number of variety of tender and auction process with one its own nuances. And we are informed that a rightful choice would assure maximization of revenue return. The term auction expressed in my instant opinion may therefore be read as to maximize revenue return irrespective of whether the means adopted to technically and correctly be described as tender auction or auction. One.
Then
186.
150, 186.
150, now my lord, 186. My lord, based on the legal, 186, my lord, based on the legal slash constitutional parameters slash requirements called out in the preceding 3 paragraphs, I shall venture an opinion whether there are circumstances in which natural resources ought to be disposed of only by ensuring maximum return. For this, I shall place reliance on a conclusion drawn in a main opinion, namely distribution of natural resources is a policy decision and a means adopted for the same are thus executive prerogative. However, when such a policy decision is not backed by social or welfare purpose, and the precious and scarce material resources are alienated for commercial pursuits of profit maximizing private entrepreneurs, adoption of means of other than that are competitive and maximize revenue may be arbitrary and face the wrath of Article 14, madam. I am in the respectful agreement with the aforesaid condition and would accordingly opine that when the natural resources are available by the state to the private persons for commercial exploitation exclusively for the individual gains, the state's endeavor must be towards maximization of revenue returns. This alone would ensure that the fundamental right enshrined in Article 14 of the Constitution and the directive principle contained in Article 39B of the Constitution have been extended to the citizens of the country. 187 also says similar, but
Same,
188 is yes, my lord, 188, my lord. In the main opinion, it has been concluded that the auction is not a constitutional mandate and in the nature of absolute principle which has to be applied in all situations. And as such, auction cannot be read into Article 14 of the Constitution of India. So as to be applied in all situations, auction is certainly not a constitutional mandate in the manner expressed, but it can surely be applied in some situations to maximize revenue returns to satisfy legal and constitutional requirements. It is therefore that I have chosen to express the manner of disposal of natural resources by using the word maximization of revenue in the place of term auction in the foregoing 2 paragraphs. But it may be pointed that the Attorney General of India acknowledged during the course of the hearing that auction by way of competitive bidding was certainly an indisputable means by which maximization of revenue returns is assured. In the aforesaid view of the matter, all that needs to be stated is if the state arrives at a conclusion in a given situation that maximum revenue would be earned by the auction of a natural resource in question, then that alone would be the process which should have to be adopted in a situation contemplated, madam. And this I am handing over, madam.
What is this 2020? Who is relying on 2020? Hare Krishna Mandir. Which says which says
Paragraph 100. 100.
oh that judgment.
What
Okay,
circumstances?
okay, fine. That exercise of power. Issue of treatment. Okay.
Madam,
You have relied on this is 2010 3 SCC page. Where is that judgment?
786.
You have relied on 2010 3 SCC page 7.
786.
786. That is Maharashtra University.
Maharashtra University.
Okay. Then you relied on the judgment of 2013 6 SCC 573.
Yes, madam.
Okay. Then now 2012 10 SCC page 1.
Page 1.
Okay. Now anything more?
Madam, 2012 11 SCC, madam.
2012 11 SCC.
Para 133, madam. That's a big judgment.
2011 SCC
No,
page
2012 volume 11 page 1.
Page 1.
Page 1. And
Earlier also 2012 10 SCC page 1.
and earlier was 2012 10
10
SCC.
SCC page 1. Now 2012 11 SCC page
Yes,
1.
yes.
Paragraph
133, madam.
133.
Well, here it is reiterated that there's a celebrated judgment of Hinstones, madam.
Monet Ispat.
Monet Ispat.
Okay.
He says there's no fundamental right. It has been reiterated it is reiterating this
Which paragraph? 133.
133, madam. And the Hinstone outside. Yes. Look, that judgment read it this man, Hinstones, man, it is referred to Hinstone. This is the Hinstone. It will take it. This is
Paragraph, Kingston
Par-
paragraph.
Kingston paragraph 6, my lord, and paragraph 10. And recently, my lord, the just a printout, my lord. This is the 2023 case, my lord. Herein, my lord, they also applied for a, this has been related at no fundamental right. And my lord, when you seek a renewal of lease and come before the court, you don't have any vested right.
Paragraph,
My lord, paragraph 17, 18, 17, 18, and 19 to 20, my lord. Even the doctrine of legitimate expectation also don't come herein, my lord.
that is in Monet Ispar also. Monet Ispar,
Yes.
that legitimate.
And the other judgments mentioned we relied on, my lord, that Arakut, my lord.
Mm.
Here, my lord, intent was to exclude.
Mm.
It was not to include, my lord. The words, my lord, the word used was to rule further all such other.
Mm.
Well, look, here the word was different, and here I have pointed out we have used the word and.
And
So
your
and
case is that
is-
when it's not conjunct, then it will
create a
will-
class of its own.
class of it. So you can have any other consideration.
My lord.
His case is that it cannot be, it is in view of the principle. This is the basic fundamental.
Yes.
argument.
It would different.
So therefore, if we uphold your argument, then the other part will not come that you have not followed the parameters.
Right.
You have considered and you relied on the clause 7 of rule 20 to rule 20.
Right.
And part
21-7.
21-7, you have 20 subclause 1 and
7.
and 7. That part you have exercised, so you cannot say that we have not
Yes.
applied our mind. This is your
And that part, I'll wrap it up. The word he's using, it may increase, it may increase. But the very correct word, because 25% is the cap.
Hmm.
Because when it's put to sale, that 25% will be added. After that, my lord, floor price increases, bidding increases. My lord.
okay.
And thereafter, my lord, very political. Do note on affidavit, my lord, I like to take liberty, my lord. My lord, he was settled with a Mohol.
I think to bias your lordship.
No,
I
this is
think
not
not
lordship.
on affidavit, some document is producing before the court. I've not been given a copy.
My lord, herein it is stated now, new settlements, my lord, the minimum quantity of mineral has to be 10,000, my lord, 10,000 cubic meter, my lord. Definitely price will increase. It is up to
No,
lord.
well, no, let us
Ah,
go to a legal
Legal point is there, my
legal
lord.
point.
That is his
Let us
case,
not-
my lord, that we cannot go beyond that. Because 7 is
Yeah,
defined with
more
6,
or less, it's like a judicial review of an order
my lord.
passed in exercise of power under rule 19 and 20. So therefore, whether his argument will uphold or your
Yes.
argument will uphold. You have exercised a power under rule 19,
My lord.
rule
we have
19 and
yes.
20. Whether according to him that exercise of power is not at all in conformity with rule 19 and 20, in view of that the principle that he is relying on, and your case is that this is
We can do that
you
because
can do that
yeah.
because you have given a leeway to determine determine the issues on the basis of the revenue also.
Right.
And judge power should be gathered from the principle of that law pronounced by the Supreme Court that it is not a right, and it's when it's a natural resources, government is within its pole to think for the highest revenue, and therefore that end should be read in conformity with that principle.
Right.
Isn't it? This is your
Yes.
argument.
Yes, definitely, exactly. And is a
Yes.
different class we can have.
Just 2 minutes.
Yes.
But,
Yes.
my learned friend, I'm not aware that this submit candidly. Now, I came from my learned friend that mining is registered commercial. I thought only alcohol. betting.
No, that is mining
Yes,
is also
yes,
in view of that
Hints
Monet
Monet,
Hinstone
yes,
initially,
yes,
then Monet
Monet.
it was
So, Manoj,
concretized.
I asked this question to myself.
Hmm.
Now, by making that statement, does he mean that even if a statutory rule has been violated, I am precluded to approach his honorable court by way of 226? That is the question what I put, but I won't argue anything further. on that.
Your answer to his argument, what I have gathered from you is that see that purpose of obtaining maximum revenue, the policy of the state to obtain maximum revenue, so far relating to a mining contract, has already been formulated in terms of the Mining Act and the rules framed thereunder.
Own good, their
And therefore, in 2013 rule, the earlier process has been negated and exclusively tender has been brought in. Because prior to 2013 rule, it's not a mandatory to have a tender.
Yes.
Is that it?
Yes.
And therefore, your argument is that even that to protect that interest, even in case of renewal, they have incorporated, legislature wisdom incorporated rule, sub-rule 3 of Rule 20. This is a
Right.
reply argument.
and my lord, the judgment what was placed by him, my lord, accused generate, just 2 paragraphs, but it's very good, my lord, and they have used. But my lord, the judgment has to be read as a whole, my lord, each paragraph. What lordship, I'll kindly note paragraph 29 and
Just a minute.
30.
Paragraph.
29
Which judgment? This is
and 30.
2000
Maharashtra University.
Maharashtra
Master. Paragraph. According to paragraph.
29 and 33. I'll just read out just one line.
Yes.
But like all other linguistic canons of construction, the existing generis principle applies only when a contrary intention does not appear. In the instant case, a contrary intention is clearly indicated. Now, my lord, has he shown what was the contrary intention? In this case, there were 2 sets of rules defining 2 different features. And again, what does 33 say, my lord? As noted above, in the instant case, there is a statutory indication. My lord, take note why the Honorable Court has held that it cannot be considered education generis, because the court has come to a finding, as noted above, in the instant case, there is a statutory indication. Now, he has not submitted that 2013 rule. There is some statutory indication to the contrary, such other would mean. And my lord, given one situation, I'm just
His
thinking of-
contention is the statutory indication is the formulation of tender itself. It says that by no other ways. So according to him, that renewal is a discretionary power. So basic concept is a tender. That will be his argument.
No,
So
also
therefore,
that
we will have to
accepting
rule as a
Yes,
rule.
that would first place, my lord, that would render the entire rule 19 and 20 odious. What is the purpose of that rule? And again, one more,
No.
and one more, just attention. He thinks such other would mean any other thing, according to him. Everything. It would be very wide. Now, Lord, you could see the amount of discretion given to the competent authority. If that was the case, he could have come to any consideration. No, I won't.
So to summarize your argument, when the rule 19 and 20 is a prescription for exercise of jurisdiction
in a certain
for
manner.
or for renewal, not for settlement, for renewal. Therefore, it should be object is to look into whether this person is proper person to get a renewal, and therefore the price or the revenue cannot be a concern so far relating to Rule 21
7 also does not come.
to 21
7.
and 7 will also not come because that purpose is sought to be achieved by legislature by incorporating Rule 3.
Yes.
This is your argument.
Yes, and one more point, my lord, by Rule 3, and also that has to be read education generis because of the earlier enumeration. And last point, my lord, this natural resources case, what he has produced, my lord, 300 paragraphs, that is totally out of context. Lord, you could take note of paragraph 120. There's one paragraph, I'll read it out. Lord, you could take note. What does it say?
Paragraph.
120.
This is Swaseng some real society.
Natural resources,
Paragraph.
120.
Okay.
120, page 88.
Read it.
Therefore, in conclusion,
Hmm.
the submission that the mandate of Article 14 is that any disposal of natural resource for commercial use must be for revenue maximization and thus by auction is based neither on law nor on logic. My lord would agree. That paragraph should have been read. That was not read. There is no constitutional imperative in the matter of economic policies. Article 14 does not predefine any economic policy as a constitutional mandate. even the mandate of Article 39B imposes no restrictions on means adopted to subserve the public good and uses the broad term distribution, suggesting that the methodology of distribution is not fixed. Economic logic establishes that alienation, allocation of natural resources to the highest bidder may not necessarily be the only way to subserve the common good and at times may run counter to public good. Hence, it needs little emphasis that disposal of natural resources through auction is clearly not a concept. So they are saying
Then I read 186 to Koilo.
No, that's fine. See, this judgment says that should be done, auction not done. But
Yes,
in
yes,
your
sir.
in a case, the policy of the state is clear. What do you mean by a policy? Policy may be by way of a legislation,
Exactly.
by way of a rule. So in that rule, they themselves say that
Yes.
it should be through auction or tender. In the policy, they give a possibility and scope of renewal. In that policy, they fix the parameter, what should be the conditions for granting and renewal. These are no dispute.
Exactly.
This is the policy. Only
Exactly,
thing
exactly.
is that whether that clause 7, subclause 7 comes with give a discretion to them to consider any other aspect of
sir.
the matter, including the price.
I say he cannot. I say
He
I
say
can
can.
because,
So
because
therefore,
word end is used.
Therefore, these are not according to me important.
Word end is used. I say I can.
The
That's all.
object of the rule is I'm a good contractor. Last time I had paid all my
We'll have
bills.
to interpret that only, that much. Okay.
I'm very grateful to you.
Heard CAV. Hearing concluded. এখানে mix না করিবা আমার note করো।
Do we give a list of judgment?
You can give it and you can give short note what you propose to do that, then it will be easy for us to.
During the course of the day, my lord?
Yes, give it. We'll finish it. Try
Tomorrow,
to
my lord, tomorrow.
tomorrow.
Deeply
My
obliged.
lord, tomorrow.
Deeply obliged.
Obliged, man. Take it.
Chamber.
I'm sorry, Lordship. There was so traffic jam.
No, that's not an issue.
I don't know. I think it will continue for quite some time.
Will continue for 1 month.
This is about it.
No, it will
Oh,
continue
initially.
initially. No, nobody can move.
I think the road itself has been. Anyway, my lord, these are the hazards of development.
Yes, what you say before you hear Mr. Chaudhary?
Lordship, as because they have not paid the amount, we have already cancelled it. And we have taken the position also.
Now, what are you doing with that thing?
We are proposing to go for a press center.
What is his proposal?
So, my lord, my humble submission is,
Uh.
my lord, I have a right of either extension or remission.
Okay.
Now, my lord,
That there is a report. There is a
only
report
1, 2,
and
3 reports.
reports are there.
Ah,
Now,
so
according to you, at least consider that
Yes, there's
report.
No, in fact, my lord, para 21.
Well, you have not
No, they have
yet
not
any
issued
tender. You have not yet issued any tender.
My lord, what I was
We have not
proposing,
yet.
my learned friend can take instruction.
That is what I am saying. That is what I am asking.
What I'm saying is, my lord, we'll pay 5 lakhs subject to outcome of the case. If the position be given up to us, let him have the instruction.
See, your concern is the revenue.
Money, yes.
Your concern is the revenue. We are not passing that order today itself. We'll have it on Monday. You have that instruction. That is the proposal of Mr. Chaudhary.
Yes.
His remission is pending, his
My lord, by their own saying, 26 lakhs is due. My lord, I pay 521 remain.
we
Depending
are not.
upon,
We are not.
and my term is up to 31st of May, March 2025.
Okay, so therefore, it's like taking a house non-payment of loan.
Yes.
Okay, so we are not saying anything on merit today. His application is pending and he offers to pay some
5
money
lakhs
also.
now.
5 lakhs now.
And I
You
said,
will have an instruction whether you are agreeable to this, number one, then we'll go to merit.
Yes.
Then another aspect of the matter is that what have you done on his representation?
Yes.
That's all.
And there's one more thing, my lord. There was a decision taken on my lord 28/7/22, whereby my lord that they would refix the revenue because of the report. That they should also complete. Para 20,
Para 20
21, page 90.
of your petition.
Yes.
Yes, thank you.
Okay. If it is there, I will.
Okay,
That is, yes, it's already there.
if there is a policy,
Yes,
then
if it is policy.
policy is, yeah, already a resolution is taken hard, Mr. K.N.
If
Chaudhary,
policy is there.
learned senior advocate assisted by Mr. A.M. Khan. A.M. Khan, learned counsel for the petitioner, and Mr. Sharma, P. Sharma, learned standing counsel for Assam Fisheries Development Corporation. The petitioner is the lessee of 23, 24, and 57 number Silosi Bill situated under Baghbar Revenue Circle in the district of Barpeta, and settlement was made in his favor on 5/11/2018 for a period of 7 years. So 7 years, full stop. It is the case of the petitioner that due to COVID pandemic, flood, erosion, etc., the petitioner suffered huge loss in managing the bill, and he failed to pay the revenue regularly to the corporation for the financial year of 2021. And as on date, there is a due of rupees 26 lakhs to the corporation. Full stop. In view, it is the further case of the petitioner that the petitioner has represented before the authority, on the basis of which certain enquiries were made and report has also been submitted, and a specific stand has been taken in the writ petition that page 19, writ petition that in the board of meeting of the corporation held on 28/7/2022, a decision was taken in the aforesaid backdrop to reduce the revenue.
Refix it.
To refix the revenue. Accordingly, Mr. K.N. Chaudhary, learned senior counsel, in the aforesaid factual backdrop, submits that the petitioner is still willing to pay an amount of rupees 5 lakh immediately, and he will continue to pay the
Refix revenue.
the revenue after refixation as proposed, and therefore during pendency of such exercise, the mohal should not be put into sale once again. Full stop. Mr. Sharma, learned standing counsel for the Fisheries Development Corporation, submits that as a specific stand has been taken that a meeting was held on 28/7/2022 for refixation of the revenue in view of the loss suffered by the petitioner, he will have to have an instruction in this regard. He further submits that though the corporation has decided to go for a resale of the mohal through tender, however, tender has not yet been issued. Full stop. In that view of the matter, Mr. Sharma submits that he may be granted some time to obtain the instruction from his client as regards the meeting dated 28/7/2022 and decision thereof, and also the offer made by the petitioner. Full stop. In view of the aforesaid, this matter, let this matter be listed on
27 and 28 anyway.
27th of March 2023. That's all.
It can come on motion itself.
Yes, motion that we have fixed it. Motion.
Highly obliged, Lord.
February. Mr. Gogoi.
I am assisting Tushar Mehta in one of the Mehta.
Okay, so what do you say? Today? 27 February.
Malona fix next week anything. Next week Thursday fix local. Wednesday, Tuesday or Thursday next week. Otherwise, if at 2 also. At 2 local.
At 2? How many methods are there?
At 2.
Okay. Today, how many? Okay, at 2 we'll give a chance, give a try.
Yes,
No,
Give a try. Okay. As per Mr. Chaudhary, is a very limited issue. Whether it can be applied retrospective or prospective.
It is up to
5 crore.
No,
Lordship,
no, that
PVC.
principle, that policy,
Lordship.
according to what, we have not gone through the
Lordship.
file. What Mr. Chaudhary has slightly, he has just placed the
Lordship.
fact, not fact, the policy that there is a change in the policy or new notification or amendment has come. By virtue of that, yes, you can take an action.
Lordship.
But according to him, that will have a prospective effect, not a retrospective effect to bring him in that fold, which the contract was executed, tender was done prior to amendment. If this is the limit,
Otherwise also Lordship, this petition is not maintainable at this stage as because there is arbitration clause there in the contract agreement itself. It's a contract agreement
Okay.
itself. Contract
Okay.
agreement itself. I will
but
argue.
if he will, I think, suppose argue that this is not arising out of contract.
Yes,
It is arising out of a amendment in some rule. I think this will be.
Otherwise also Lordship, PVC Lordship, some we have rejected his claim, then you have to go to arbitrator. Lordship.
Okay, we'll see that.
Yeah, go to
Okay, okay.
arbitral.
These are all open. These are all open.
Lordship, Lordship.
We'll take it to.
Lordship, Lordship.
How many matters are there? Okay. Then next we'll take up this matter.
Sure.
Maybe little bit 2, 5, 2, 10. We do not know. We have some program in.
Lordship,
bar.
Lordship. No.
We hope we'll meet Mr. Chaudhary also there. No, in the bar we'll hoping to meet you at this. Kuntu was hearing Kuntu was there. 22, 22, 23, and 26. Okay, we'll
Otherwise,
take up.
Lordship may pick on Tuesday also, Lordship. So our one of the matter probably 2:30 there we taken. Lordship. I have.
Tuesday, I have some other.
Then Lordship, any day, Lordship.
Give us a date, Mr.
Any day,
Chaudhary. Then I will not do it half-hearted
No,
because
no,
this
no,
bench
no,
is till
no,
Friday.
no.
Let me be clear.
Today morning, I
Thank-
am extremely sorry, Lordship. I was there, Lordship.
Tomorrow, I'll.
Tomorrow, Friday may not be possible. We do not know how.
My humble submission for your topic. This matter is pending long back, madam. And
Okay, well, let us start today.
Lordship, Lordship.
Okay.
It's a 2023 matter.
well, it is a tender matter, my lord,
Okay.
PVC, my lord.
Lordship.
Okay, okay. We'll see.
Lord,
If not possible, then we'll. Yes, Mr. Chaudhary.
Taking up item number 17.
Item 17. Definitely. No, that these are all you are for
27, sorry, not 17, 27.
27. Who is minor minerals?
Fine.
Yes, Mr. Mohanta was there.
Mohanto was
And
there.
I'm
He represents.
You are not giving him. What was the issue here?
Issue is that my.
Are you ready? If you are
Yes,
ready,
yes.
we can.
Yes, yes.
If Mr. Chaudhary's method, we can complete. We'll
Yes.
go. You will give a chance. We'll take a chance.
Yes,
It's
yes,
possible or not.
My lord.
Okay.
My lord.
May it please your Lordship. My Lord,
Yes.
take up the petition number 983 of the.
Let's give the next. Just give me a minute. Okay. Yes, when is the last date of tender?
It's 26, my Lord. The closing date is 26.
26.
Yes.
And when was the date issued?
It was issued on, my Lord, we have taken the tender document. my Lord.
When was the notice issued?
Notice was issued on in January.
And
Publication-
what was the date fixed for site visit?
There is no date fix. We have to go there,
Hmm.
and they would take us, guide us to the site, and they will issue a certificate. It was not done.
Now, when did you visit?
We have given a statement on 9th of February. We went there.
Hmm.
We requested them to entrust the person. They said there is no person available.
Where is the tender?
Pardon?
Where is the tender?
That condition
Notice,
you're not,
notice,
tender
tender
notice,
notice.
tender notice is at my lord page 41 and except 4. We are interested in this petition that serial number 1. And the relevant dates
Page 41,
page 41. Serial number 1.
page 41, serial number 1. Flood prevention of Pohumara River.
Pohumara River in Badauli district, phase 2.
Okay.
Then my
Now,
lord will come to the tender condition at page 53.
now last date and time of submission is 15/2.
No, it is written 15/2, but if inside your lordship is, go to the inside, then lordship will count my lord at page 46. Which submission end date, serial number 4,
End date is
26 Feb. That was inadvertently written there. In notice, it is all dates are 15 February.
Where is the condition?
That is the, my lord will see, general tender condition, page 53, my lord. Point K,
Yes.
point K, page 53. Site visit verification report issued by the executive engineer has to be mandatorily submitted along with the technical bid. So
Okay.
in absence of that certificate, my tender will not be accepted. And the same thing is again reiterated at page 54, my lord. Point number 7.
What number?
7.
Page?
Sorry, my lord. Page 56,
Yes.
point number 12, last point P.
How the site verification is defined in the tender document?
No, there's no definition of site. And there is no procedure they have prescribed how to, if there is any, if that at all requires any application from the interested bidder, nothing.
Yes, yes.
Lordship, as per my telephonic instructions which I have received from the department as well as from the executive engineer, that although the petitioners has annexed a letter that they have approached the executive engineer, but in fact, on record, no such letter has been received by the executive engineer.
They will visit you tomorrow.
Tomorrow, my lord.
Definitely.
Tomorrow, we are fixing this matter on Monday. Issue a certificate. By tomorrow itself. You need a visit only,
There
nothing.
is nothing else.
They will
That
visit and
certificate is-
executive engineer will issue a certificate.
Issue.
That's
If
it.
you will issue a certificate.
Yes,
Okay.
Then we will
once they
participate.
approve,
Then they will participate. Tomorrow is
Tomorrow is Friday,
no Friday we know, but date
23rd.
23rd.
We enough time.
Enough time.
Because it is e-tender, we have to upload only.
Upload on. Okay. Third, Mr. Somo, Learned Counsel for the petitioner, and Mr. R.M. Das, Learned Counsel representing the respondents. The petitioner, who claims to be a registered partnership of, is desirous of participating in the tender process initiated by
Water Resource Department,
Water Resource Department
Government of Assam.
in respect of work within bracket flood prevention of Pohumara River in Brazali district phase 2. Full stop. According to the petitioner, he has purchased the tender document and is ready to submit his bid. He is ready to submit his bid within the stipulated period of 26th of February 2022. However, he has not been able to complete his bid document in view of want of site visit verification report,
To be
which is required to be issued by the executive engineer in terms of tender condition. Full stop. The petitioner had made a specific statement at paragraph
9.
9 of the writ
No,
petition.
sorry, paragraph 7.
Paragraph 7 of the writ petition that the petitioner, very specific statement that the petitioner sent his officer plus attorney for site visit on 9/2/2024. However, the executive engineer Bozali refused to entrust any person to accompany the petitioner's attorney for visiting the site. Not visiting the site and did not visiting the site, and therefore the petitioner slash petitioner's representative could not visit the site, and the executive engineer did not issue any certificate. Full stop. The tender document, full stop. Tender document stipulates, tender condition stipulates that page, just now we are in the page.
Yes, my lord, that page 53.
Page 53. Tender condition under qualification of bidder mandates that site verification report issued by the executive engineer has to be mandatorily submitted along with the technical bid. However, Mr. R.M. Das could not show this court any prescribed procedure and any prescribed procedure under which executive engineer shall issue a site verification. That being the position, and that being the position, and in view of in the backdrop of alleged fact that the petitioner did visited, petitioner's representative did visited the office of the executive engineer Bozali, but nobody accompanied him for site visit, and therefore there was no certificate to be, no certificate was issued, this court as an interim measure provides that the petitioner shall visit the office of the executive engineer tomorrow by 10:30. At 10:30, not 5, we need a copy. 10:30 a.m. At 10:30 a.m. and on such visit, the executive engineer or his representative shall facilitate the petitioner to visit the site, and thereafter the said executive engineer shall issue executive engineer or his will not say delegate, because here is a executive engineer shall issue a certificate as required under the tender clause 4 within bracket 1 within bracket K. Full stop. K. Full stop. Mr. Das has assured that he is personally communicate this order, passing of this order to the executive engineer telephony. Achha. Though Mr. Das has on instruction submitted that the petitioner has never visited the executive engineer, same be drawn on record by way of an affidavit. Full stop. Full stop. The participation of the petitioners in the tender process. Thereafter, the petitioner shall be at liberty to submit his document. Full stop. Submit his bid. Full stop. If they are correct, you have not done any, you have created a problem for this court unlisted, then we will not allow it. The participation of the petitioner shall be subject to the outcome.
Look, we are just asking for a participation.
But if you have not done and you are alleging wrong facts against them, then why should we not give you a heavy cost?
We are on oath, Philip.
They will also on oath. Then
But there is
put a CCTV camera.
My lord,
My lord,
Why this kind of condition? There should be some procedure that he will
he'll
notify
apply, he'll
notify by a mail that he will visit on such and
Oh,
such
such
that
and such.
accordingly.
Nothing
Then
like
at
that.
least we could have said. Now he will say I have gone. You will say I have not gone. He has to make allegation that you I
Yes,
can
Lord.
ask him not to participate. Anyway, last part na lage, huh? Subject or complete. List this matter on.
After we,
By the time it will be in fact.
Otherwise, it will be success if they do not issue.
Otherwise, huh?
If
No,
they
no,
do
we
not,
will.
if they do not comply with
List
this,
this.
if I am assuring this court, Lordship, this honorable court.
Let
Yes,
let him participate.
Yes,
yes.
See, that executive engineer should not behave like we
No,
need
no.
a participation. He might have some interest there.
No, no.
We'll take stern action if he's
Yes,
not
yes.
allowed.
If the provided the petitioner participate means visit the place.
But Mr. Someone tell your client also.
So we'll produce evidence that we have.
Okay. List on 27th.
Well, in 982, Miller, the second bit matter,
Uh.
same thing, Miller. We have given specific statement, but here the only difference is that it is already closed. In this case,
If it is
notification-
closed, then we'll not.
No, we are challenging the
Tender
validity
condition.
of that.
Heard
particular-
Mr.
No, no.
Heard Mr. Somwa, learned counsel for the petitioner, প্রথম part to একে থাকিব, issue notice, returnable that Felix. After 4 weeks, Mr. RM does accept notice
Accept.
on behalf of all the
All the-
respondents.
Obliged.
Extra copies, 5 days.
Sorry.
একটু করে দিবা আগে। আবার পারে যদি এটা করো। Yes, two, I can. What is your instruction? Not.
I have spoke to them.
Ah.
They just want to verify the annexures in the petition.
Hmm.
Kindly pick it up tomorrow.
Okay.
Tomorrow.
It is submitted by the learned counsel for the petitioner that the dispute involved in this case is squarely covers in the decision rendered by this court in
In my lord, IA civil.
IA in IA
Number
civil
43, my lord.
IA civil 139/2022 arising out of WPC
Number
arising out of
Page 74. Page 4475.
arising out of where
74.
Page 74 first one. Page 74.
I meant page 74.
The order starts from the
How does that?
last line.
Okay. WPC 4475/2021 and other connected cases.
Stop.
Full stop. And therefore, the said judgment shall also cover the case of the petition. Mr. Dean at Learned Counsel, Learned Senior Government Advocate submits that he may be granted time till tomorrow to go through the judgments and the facts of the present case and respond to such. Full stop. Prayer is allowed. Please this method tomorrow. You will definitely verify. That is the order. On legs. Okay, some exercise for Mr. Chaudhary in the lift.
I know, but I didn't say that.
Don't say that. He is a lawyer. He comes and argues.
Mr. Sudhir said something, so I'll take right. Normally, I am not saying.
He submitted that Mr.
Annexure. It's okay.
K. Gogoi, Learned Arguel Council, is having some difficulty. Okay, accordingly, press for an adjournment. Prayers cancel out. Please this method.
Okay, right.
When?
I suppose.
Sometimes you'll have to keep mum, Mr. Sudhiri.
Yes,
Do you remember?
yes, my lord.
Yes.
Absolutely correct.
Huh?
If you look to put up this thing, my lord, I can say many things. Nowadays, that is
So
the
sometimes
same
you'll
way.
have to keep
Yes,
mum. That's why I'll say not
Yes,
more than that. Yes. Next, after 10 days. He's here. It will take some time, Mr. Chaudhary.
It will not take time, my
Okay.
lord.
Okay, let us start. Hey, গরম লাগছে। Yes, what is the issue here? Where is the impugned
Issue
order?
is that, my lord,
Where is the impugned order?
yes, my lord. Impugned order, my lord,
What is PVC bill?
PVC মানে price variation clause, my lord.
Okay,
Yes, my lord. As per price variation clause, my lord, they have categorically stated, I am coming, my lord. Your lordship kindly come to the, my lord, page 50, my lord, 7, the page 27, my lord.
base
27. What is price variation, my lord, clause? And your lordship kindly paragraph,
the order.
my lord.
Hmm?
Point number 6.
Huh?
Point number 6.
Page 27.
Yes, my lord. Price variation clause is not applicable for tender having less than 5 crore.
Northeast Frontier Railway 38.
Yes, my lord.
Now,
The word has been used, my lord, for tender.
okay, page 27.
Yes, my lord. Page 27,
Clause
clause 6, my lord, point 6. Joint venture,
price variation.
yes, my lord. Price variation clause,
Hmm.
last purpose is not applicable for tender having less than 5 crore. If
Okay.
the tender value is less than 5 crore, then PVC is not applicable.
Okay.
Here, tender value is, my lord, 5 crore 61 lakh 10,418, my lord.
Okay. Understand?
lord.
According to you, in terms of this
Yes, my lord.
single packet tender,
Yes, my lord. And
this
my
is
lord,
a tender notice where you have participated.
yes, my lord.
Tender value is 561
Yes, my lord.
10418.
Yes, my
This is the tender you have
Yes, my
participated
lord.
and you were awarded.
Yes, my lord.
Where is your award?
Award is yellow signal page annex 30 page 31, my lord.
Page 31.
Yes, my lord. This is my lord. Appreciation value of the work, my lord. This is the my lord, work order.
Hmm.
4 crore 53 lakh 21,255, my lord.
Okay.
Yes, my lord. This is my tender. This is my lord. Offered bid, my lord, in the tender. Then your lord come to the my lord. Price variation clause page 34, my lord.
Page 34.
Yes, my lord.
This is
What is price variation clause?
and this is the clause under your contract.
Yes, my lord.
Page then
Page 34.
page 34. Yes.
Price variation clause shall be applicable only in those contract conditions for material supplied to the railway to the extra NS item into the subsequent variation outside the
Just a
purview.
minute. This is price variation. Okay, go slowly. Price variation clause shall be applicable only in those contract.
Tender conditions specifically permitted. Material supplied free of cost railway to the contractor, extra NS item into the subsequent variation falling outside the purview of schedule item of the tender shall fall outside the purview of price variation clause if any case accepted offer includes specific payment made consultant material supply railway fee or fixed such payment shall be gross value of the work for the purpose of recovery of price variation. If the tender condition specifically said here is a price variation clause, then that is applicable. In this tender, that is specifically, my lord, available in this tender. But it is not disputed by them also in their affidavit that price variation clause is not available in the condition of the tender.
Just a minute. Okay, now
Yes, my lord. I have submitted, my lord,
tender.
price escalation bill.
Where is that?
Page 44, 18, my lord. All the bill. This is the amount mentioned, my lord. Escalation bill. That is price bill.
Price variation. Okay.
Yes, my lord. Page 44. 94 lakh.
Now, where is the subsequent that?
Yes, my lord. I am coming, my lord, one by one, my lord. One important thing is that is important matter. That's why I am so sure.
Which one?
Yes, my lord. That is value, my lord. 94 lakh.
Page.
Page 44.
Page 44.
Yes, my lord. Yes, sir.
Okay, this is your price escalation bill.
Bill.
Okay.
Then page 35, my lord, impugn order. That's
Just,
one of the impugn.
just a minute, huh? Okay, page 34.
Page 55, my lord.
Now I will go to page 55.
55. Report. They said, my lord, impugn, my lord, with reference to the
Just a minute, just a minute. Page 55.
With reference to the cited CA, this is inform you that
Hmm.
senior AFA con NJP has returned your submitted bill. Contract value of this tender is 4.53.21 against which LAO issued on 4/3/2020.
Hmm.
As per existing rule and for clarification placed SN 37 copy and close. Contract agreement value less than 5 crore PVC shall not be applicable for the instant case. Now they have given twist, my lord.
Hmm.
You all also kindly see the actual terms and condition, it is a tender value. Now they have changed it is said that contract value.
No, that where is that clear clause? Because they are interpreting on the basis of some clarification.
I'm coming, my lord.
Where is the
Yes,
clarification?
my lord. Before that, one thing is that, my lord. Kindly page 57. Only one document.
Page 57.
That is their engineering department document. That is their document, page
Hmm.
57.
Hmm.
Second paragraph.
Hmm.
As per item.
Just a minute, let me note
Page
it.
57.
Page 57.
Yes.
Okay.
As per item number 8, railway board letter mentioned above, SN 33 PVC is not applicable in all contract work contract tender having less than 5 crore.
Hmm.
The instant tender was called having tender value is rupees 5 crore 61 lakh.
I understand. What is your argument is
Yes, my lord.
it is not the actual price offer.
Yes.
It is the tender value of the contract on the basis of which
Yes, my
it will be it is to be decided whether PVC is applicable or not.
yes, my lord.
In my case, according to you, in my case, a clear, if we look into the tender clause, the value is more than 5 crore.
Yes, sir.
I may have about 4.53,
Yes, sir.
but when it is a tender condition and subsequent communication that that rule you have said, which also said it's a tender value, not a contract value. Therefore, PVC is applicable.
Yes, my tender has been called by this person.
Hmm.
Con, my lord, officer super con department of construction department. Con means construction department. And he has said, man, what he has said. The instant tender was 5 crores in NIT place.
So he has made an opinion
Yeah.
that it is not here it said there is a contract value.
He said contract value is something different, but tender value is 5 crore 61. He said the person who has called quoted the tender. Accordingly, PVC was incorporated in the tender document as well in contract agreement based on GCC 2019.
Hmm.
Railway board on 2015 2004 in view of the
Where is the railway board's decision?
railway board decision. I put the file. Next page they have said, my lord. I'm coming in, my lord, page 58, my lord.
Yes.
Yes, this is the accounts department, my lord. Contract value of this tender is against 4 crore 53 against which LOS 4/3/2003 as per existing rule in FAC and clarification SN 37.
Hmm.
Contract agreement value 5 crore PVC shall not be applicable for the instant.
Where is that SN 37?
SN 37, your lordship will come, my lord.
Hmm.
Lordship kindly come to their document, my lord.
Page 60?
Yes, my lord.
Huh?
Yes, my lord.
Page 37?
Page 60, SN 37.
Yes.
That is
Which
said,
clause?
they have said, my lord, SN 37,
Hmm.
that in terms of the railway board effort favor,
No, which one? There is a SN
they have used
paragraph 1, paragraph 2. Which should you read? PVC
paragraph
46A.1. Huh?
Yes, yes, my lord. Page para 3, my lord. File variation clause shall be applicable 50 lakhs or more.
Just a minute, tender value prescribed
Yes,
by the
madam.
Ministry of
Next,
Railways.
46.1.
Just a minute. Time. Is the contract completed material supplied free of cost by the relay of price variation clause? If any modification, what is modification? Price variation clause shall be applicable only for the contracts of value as prescribed by Ministry of Railways to instruction circular issued from time to time and irrespective of contract qualification. Variation of quantity. Okay.
Next point, my lord. Price variation clause shall be applicable only for tenders prescribed in the ministry. Next, my lord, modified. Price shall be applicable
So
for
applicable only for in place of tenders, the word contracts is replaced
It was it, my lord.
by SN 37.
SN 37 means it is an addendum, my lord, of GCC 2014. As my lord, construction department has said.
Now, when this SNS, this modification was made?
It was on 2014.
Modification was made on 2014.
Thereafter 2019 GCC come, my lord. And after 2018 GCC also come, my lord. Thereafter 2019 GCC come. 2019 GCC, my lord, there is no such type of, my lord, condition. Now they are using hidden criteria, my lord. 2014 GCC, one addendum, they want to say, my lord, that this is not applicable for this tender value, which is, my lord, tender where price bid has been offered by the petitioner less than 5 crore. That is their case. If you look to go their affidavit, and my lord, I want to show another document, my lord, where PVC is not applicable, my lord. They have, my lord, categorically, my lord, cut down like this for the page 65 onwards, my lord.
Just we want to note certain dates.
Yes, ma'am.
When the tender was issued?
Yes, ma'am. Tender was issued on, my lord. I'm coming, my lord. Notice inviting tender 13/12/2019.
13/12/2019.
Yes,
Okay.
Then, my lord, letter of acceptance 4/3/2020.
This is tender.
Yes, my lord. And
letter of acceptance
4/3/2020.
4/3/2020.
Yes, sir, 2020. Then, my lord, there is an agreement between the party. It was 20.
Acceptance. Just a minute. 4/3/2020 letter of
Yes,
acceptance.
my lord.
Then contract signed on
Yes, sir, 28/8/2020.
28/8/2020.
Yes, my lord.
Contract.
Yes, ma'am.
Now, tell me, what was the GCC applicable on 13/2/2019?
GCC 2019, ma'am. That GCC is available with me, ma'am.
GCC 2019.
Yes, sir.
Now, what does GCC says?
GCC is nothing said.
No, regarding PVC.
The PVC said, ma'am.
What says PVC? What about PVC?
PVC will be applicable, my lord. Tender will, I am coming, my lord.
Where is the GCC PVC?
Yes, my lord.
Clause 2009 general PVC.
Yes, my lord. I will give later on. Just a minute, my lord.
No, just so according to you, in 2019 PVC,
Yes, my lord.
and your in the tender,
Yes, sir.
it was provided that PVC will be applicable in respect of tender value of above 5 crore.
This is now it is 50 lakhs, I think, my lord.
No.
Now, my lord, 2019 GCC, my lord. I will come, my lord.
What GCC was applicable to your case when tender was issued?
2019, my lord.
So in 2019, what is the PVC clause?
Yes, my lord. I come.
Now this chapter 3 at page 33,
Yes,
what
sir.
is this? This is part of page 33.
Page 33, my lord.
Is part of,
It is part of my lord special condition of contract.
so this is special
Condition of contract.
condition of contract.
Yes, my lord.
Okay. Now,
Suppose my lord,
no, just therefore let us have a clarification. Suppose Railway Board made a amendment
Yes,
way
sir.
back in the 2012,
Yes, sir.
2014 to the GCC, General Clause, Condition of Contract. Now, as per that, in 2019, GCC was as per Railway Board, for assuming for a moment.
Yes, sir.
Okay. However, in your special condition of contract is there is a contradiction between the special clauses, special condition and general condition.
Yes.
Which one will prevail?
Special condition.
Where is that term in the tender?
In terms of the tender, my
That is definitely there. I could not find it out. That
yes,
is
my lord, I
definitely there.
could not find it.
See, here issue is simple.
Yes.
It is not as a, it is subject to what you argue, what we have understood it.
Yes.
There was whether the amount is tender or contract so far relating to PVC was clarified by an amendment proposed by the Railway Board in the year 2014.
Yes, sir.
That was there. There is no dispute on that.
2000, when my humble submission comes, one thing sir, before you go. When 2019 GCC has come, my lord,
Hmm.
it is the construction department. 2014 GCC is no value in the eye of law.
Yes.
Addendum, everything is go, my lord.
No, we understand.
Yes, my lord.
Understand.
2019.
So, therefore,
Yes, my lord.
what is the clause in 2019 GCC?
Yes, my
That is why I have asked, where is the
Yes, my lord.
2019 GCC?
Written, my
Number
lord.
one,
Yes, my lord.
suppose we assume that as per the GCC and special condition of contract,
Yes, sir.
that is what you argue, then is a different issue. Suppose GCC is something different in terms of 2014 amendment.
Yes.
That from 2014 all GCC, there is a proposal to do that, and according GCC's clause was different in terms of the Railway Board's decision 2014. However, in the special condition, that has been same clause written differently. One it is said to be contract, other it is said to be tender.
Yes, sir.
Now which one will prevail?
Special condition.
So where is the clause? And what is the clause in 2019? That is the simple issue.
Yes, sir. And my lord, my humble submission before your lordship is
All other things will come
Yes,
later
my
on.
lord. 2000 when 2019 GCC has come, my lord. 2014 GCC is no value in the eye
Understand?
of
You
law, my lord.
want to say when
my
there is a new GCC,
Yes, my
that will mean this is a general condition of contract
Yes, my-
applicable on the date when my tender was issued.
Yes, my lord.
And if there is a conformity between the general condition of contract,
Yes, my lord.
special condition of contract, and the tender, the GCC will available. You cannot take my right
Yes,
on the basis of
2014
2014.
addendum.
So therefore, we want to see the GCC.
Yes, my lord. Even it is assuming, but not admitting. I am quite good. Suppose GCC, this clause is not available.
No, then
Uh,
special condition. But it-
that, my lord,
suppose there is
2014 they
see
cannot use.
there may be three situations.
Yes.
First is GCC condition, special contract, and the tender are in the
Yes, sir.
similar footing.
Yes,
This
sir.
is one. Other is GCC is different, as special condition is different, tender is different. Third is GCC is different, tender and condition of contracts are same.
Yes, sir.
So that is will click. So therefore, we have to see the GCC as on 2019. Where is that?
And it is available, my lord. I have to go to it. And
Then you go through it. We'll come back next week.
yes, my lord. And another thing is that, my lord, my humble submission is something.
Hmm.
Why, my lord, construction has failed. When, my lord,
No, construction may say many things, but we must have a satisfaction.
Yes,
Is
my
that
lord.
it?
Yes, my
We'll go not
Suppose,
by
my
the, he may say sun
yes, my lord. Suppose,
rises in the west.
yes, my lord. Suppose, my lord, this clause is not a price variation clause not mentioned in the 2019.
Then your
Suppose-
special condition will
Special
applicable.
condition
If
from
there is nothing on
Special
special,
condition
if there is nothing on special condition,
Yes.
then tender condition will be applicable.
tender condition.
So therefore, we want to have a satisfaction that
special
what is the
condition.
clause in GCC?
Special condition that is available. Price
No,
variation
we have
clause
seen,
is
we have seen
applicable.
price,
Yes, sir.
special we have seen.
Yes, special that is available, my lord. In their
Now,
application.
suppose you say that GCC is different,
Yes, sir.
then which one will prevail? Special contract, where is the condition? There is some condition in the contract. If there is a contradiction, this, but we cannot allow you to do homework here.
Yes, my lord. That also there.
Okay.
Correct, my lord. But condition is there, 5
Ah.
to tender.
The issue is very limited.
Yes, my lord.
If everything is same, it's a different. If there are differences, then what will be the interpretation?
Yes, my lord.
We are not deciding what is your price contract, what should be in escalation or not,
I have
because
not-
your whole consideration is rejected on the ground that this is not applicable. We are here to determine whether regarding the applicability,
that
not
is-
nothing more,
that is my lord.
nothing more.
And as per the
For
condition-
that GCC clause is very important.
Yes, sir.
List this matter on the prayer of the learned council for the parties. List this matter. When?
I don't know, my lord.
No, what else? I was ready today.
My lord. 26 February.
26 that matter is again 6 months.
Oh, yes.
Then lordship, it will be.
Right.
Name March first week of March, give a date.
Right, my lord.
5th of March.
I can it.
Already.
Pattern. This is limited issue. Very limited. If you can show that these are, I think Mr. Gogoi, subject to what you argue, alternative remedy and all, we are not going to decide any dispute as such.
Yes,
Lord.
There is no dispute whether your rejection is reasonable.
Valid or not.
Valid. Even we are not going for validity, whether it is in terms of the contract condition.
Lordship,
That's all.
Lordship.
Rest is yours. Whether he is entitled for that
Lordship.
bill, not, that is different.
Lordship.
You have even rejected his right for consideration.
That
Whether
is-
you pay it or not pay it, this is
that
not
is
the,
the-
not our lookout. Our lookout is that only.
Lordship.
Hard in part.
Already.
Mr. Gogo, you will also look into these are the issues. There is a condition. Tender is specific that it should be tender value.
Lordship.
Special contract is it is tender value. But what do GCC we say we do not know. Now your proposition, what we can gather from this thing is that there was an amendment to the GCC long back. Now therefore we'll have to answer. Suppose there is a resolution by the board. There are these changes of GCC year to year. There is a 2019 GCC.
Even 2024 this is also coming.
Come on. So how this GCC comes out? We'll ask this question.
Lordship.
How these GCCs are born?
Lord.
So if there must be procedure of
Lord.
bond. So moment it is bond, then what can you bring on earlier amendment made to an earlier GCC?
Lordship. That is there, Lordship.
Hmm.
As per time to time railway board circular is applicable.
So suppose time to
Lordship.
time railway board circular, but one person when he offers a tender,
Lordship.
he offers a price of 4.5.
Lordship.
He thinks that there will be price escalation, so I will not quote the escalation as on now. He may think that okay, there is price escalation. If I quote it, I will claim that later on. There will be a variation of price. So it cannot be a hidden criteria. If it is okay, if there is something on the GCC itself, only there is a contradiction, then it may be different. But if nowhere the clause is there, then what will happen? That
That-
will have to answer.
That also discussed by our High Court, Lordship, in one of the cases.
Okay.
And it was go up to the Supreme Court. Supreme Court also appeal our decision.
Okay,
I'll place
fine,
it. I'll
fine,
place it.
okay,
I'll place it.
okay.
Apology.
We exchange the judgments before so that
Lordship.
we need not waste time.
Lordship.
If what judgment you want to relieve, give it to
Regarding
him.
price escalation, Lordship, I will.
Okay, and you also give the
Lordship.
judgment to
Yes.
them. It will be easier for us.
Even Lordship, that particular matter before arbitrate. Honorable High Court says that, Lordship, the price escalation part is not there, so Honorable High Court rejected the award which was given by the arbitrator. It was, Lordship, set aside by the Honorable our High Court.
No,
Then
that
it-
is a different issue.
Lord,
Our issue is basically will confine to the issue whether PVC was applicable or not.
Lord,
That's all.
that was also in the
Okay,
judgment.
okay, we'll see.
In the judgment. Obliged.
Just Mr. Chaudhary, prepare a list when tender was issued, what are the
Yeah,
dates.
everything will.
Yes. Item number 22. Yes, Mr. Roy, what is this?
Wait, the kids happen. Better is keep it high.
Oh, then we cannot take risk. Go and take rest.
I was well, but when I saw the
Okay, okay.
pressure,
We,
I
we do not want a repetition
that
of
was-
what happened earlier.
Actually, I-
Okay, go and take rest.
So
It is
I-
submitted that Mr. J. Roy Lana, Senior Counsel, is not well today. Accordingly, prayer for adjournment is made on his behalf. Prayer is allowed. List this method.
fifth fight.
We're not fixing any urgency.
I think
We're not fixing because this court may not sit in the next week for this method.
That whenever-
So the other benches, we are not fixing it after 2 weeks. You be get well soon and
It's
that's important.
Huh?
Even my lord that date,
date we are not giving today. You make a mention. We are just adjourning for 2 weeks. Okay.
2 weeks, my lord, that suddenly is I have outfit for that because the
Okay. When 3 weeks.
let it be on that, my lord. 15th, my lord, Friday,
Hearing matter Friday.
or sorry, 14th. my
Okay.
Thursday.
14.
Actually, I the pressure it was high. Now I'm feeling bad.
Since morning he is feeling bad.
Okay. You ought to have said while sitting. I would have.
That I have told him.
Why should you wait for? If you are not keeping well, anybody cannot. Or not you. Anybody can say that I'm not.
I was well, my lord, but the moment is with the pressure.
Go. Take rest.
Okay.
Yes. Where is excise? Anything survives. That judgment is diluted. Wine shops are being operated. Isn't it? I think there is some recent direction of this Honorable Supreme Court also. Dismiss it for default. I do not think. This was a highway. There are some order which says that don't operate in view of Supreme Court judgment. There is no interim order. Court says that PW will clarify whether it's a state highway. That order has also in the meantime been diluted by different subsequent orders of the Honorable Apex Court. So if you want to come on again, therefore will not enter into the merit and dismiss it for default. If he comes again, we'll take up it.
2017.
9 appears put a petitioner on call to Mr. K. Goboi, learned counsel for the respondent. This method or dismiss this method. Chaudhary.
This is a matter regarding the matter tender to my lord and Mahal. I was the highest bidder, my lord. But my bid was cancelled on 2 grounds. First ground was that, my lord, in that courtship stamp which I had appealed, I had put my signature across the courtship stamp. And my lord, on that declaration, there was, my lord, no date. Even though it is not a, my lord, statement from the department that was submitted later on or after the, my lord, bids were closed or whatever.
Where is the reject order of rejection?
The rejection order was not there, but the work has been allotted to the private respondent.
Now, what is the stand in the affidavit?
The stand in the affidavit is just as I have told, my lord. If your lordship kindly turn to the affidavit filed by the government,
Hmm.
the PPC, at page number 130,
Where is the tender?
tender your lordship find at page, my lord, 20.
Yes.
20.
Yes, 20.
20.
20 is not legible.
My lord, a better copy is available in that, my lord, affidavit of the response number 5, my lord. And the lordship may kindly, my lord, take up page 137, my lord. 136.
Delete 37.
Yes, my lord. Annexure A.
No,
to the
there is
affidavit.
something different. 137.
Turning page 137, my lord. In the affidavit in opposition filed by the respondent, my lord, 7, my lord. No problem.
Why?
Vishnu Brahma.
Dibakar Das.
Dibakar Das is, my lord, that is the affidavit in opposition of,
Vishnu Brahma.
yes,
Then this page 156, not 135.
registration is from here.
150.
That is the running page number 8. One both our record is 137, my lord.
Earlier it was 137, now that has been removed and one.
Oh, achha, my lord.
What are the imported contracts for the this dispute condition? What are the important conditions for this dispute?
Conditions, my lord, actually has not been violated in any manner. When they have rejected my tender and we came up, my lord,
Hmm.
then by that, my lord, affidavit filed by the respondent member, my lord, 2. They
Who is representing the authority?
authority, my lord, earlier, Vitarani Ita Bora appeared.
Now,
Today, I am told that someone else will be appearing.
who someone else? Because you want to see the record.
Yes, my lord.
Because what are the reasons for rejection? Only affidavit will not do.
That minutes of the, my lord, tender committee meeting has to be very important
Very
here.
important.
Very
That's why
important.
where is the?
Because I have not.
This is the difficulty. We are working
exactly.
here for these matters. Either he get it or don't
Yes.
get it. That is a different issue.
Appearing, my lord, of each and every date, my lord, somehow, my lord.
This is BTC's really. We are now called
No,
for the
I have
personality.
seen that, my lord, that in the affidavit also, they have not annexed the that resolution of the minutes.
No,
of the meeting.
therefore I have asked a question. Where is the rejection of your bid? Reason. There is no
there is no
impugn
rejection
order.
order.
If there is no impugn order, then we'll have to rely on the record, not affidavit.
Yes.
We'll have to see that these are the proceedings of the minutes of the tender committee,
Exactly.
and these are the reasons rejected.
So
Now we'll certify whether these conditions are. Yes, Mr. BTC is always records are there.
Next week.
You should have told in the morning. He's waiting from the morning.
No, Lordship, I received it lately, and I was on legs in court number 27, Lordship. matter
Mr.
was-
Chaudhuri, fixing Tuesday is difficult for this court.
I understand, my lord.
Why? We do not know how the other benches plan
I-
things.
I-
Because we are planning things on our own way. I am taking this bench for 3 weeks, suppose. I'll plan that this method requires early hearing, so we'll fix in certain dates. This method requires record. Now this will be putting another burden on that court. Is that it? And this is admittedly it's till tomorrow, this bench court.
Yeah.
This week only.
What can I do, my lord? Actually, I am told, my lord, now Mr. Mohanto, my lord, he says that, my lord, works are not being carried out. And my lord, I am daily being, my lord, Bajaj, my lord, saying that, my lord, works are going on, my lord.
The pressure is somewhere from somewhere else.
No, that,
Pressure is from somewhere else.
what happened that, my lord, EC, my lord, that is the environment clearance is very important here.
Mm.
environment clearance, my lord, he was not there in fact. Now committee has been constituted, I came to know. So now probably.
So without EC tender is complete.
No, actually no, after getting
No,
the.
I tell you, the problem is this. To sell some foreign forest products, first of all, you will have to have a EC
Environment
clearance,
clearance.
environment clearance, and that is to be applied by the user agency. Okay? In terms of the
Exactly.
Goda, there are some judgment. TN and Godavari. Now, thereafter, some rules are also framed. So, first of all, the user agency will have to apply for the permission that please permit us to have a mining or
Mining.
whatsoever.
Mining.
Mining. Now, that will be assessed by the central ministry, not here.
The mining plan.
That there will be a mining plan. Everything will be done, then lots of money will be spent. Let me be frank, spent, and thereafter, ministry will give a permission. Now, government's plan is actually user agency is government, isn't it?
Yes.
So it is government want to use it. Whether they will give under tender or it's a different issue. So they are the user agency. But what they cannot spend money, this kind of money.
That's why it is burden on the.
So they say that
On the contractor.
they issue a tender before they are permitted to lease it.
And it's always written in the tender condition.
Subject to EC clearance.
Now how can you
The
issue,
mining plan.
can you issue
Including
a
the burden on the-
tender? No. How can you issue a tender when you are not the user agency?
No mining plan. Without mining plan, how?
You are not even user agency. Forget about mining plan. How can you?
That's going on. In every mining that money
And as a lawyer, I argue
That is why
that.
I was just about to
And
say.
what happened in that case is that a person who done everything
He
to
ultimately-
get the permit,
he did not get.
thereafter they wanted to give him directly. Then the other party, my client came and we fought it case that no, you cannot have it by virtue of 2013 rule, you cannot do by. That is a reported judgment. And his all dreams and aspiration is gone. Therefore, now what they are doing is
That is what
before they are
I
giving.
was just about to tell my lord that because your lordship were here or sometime before, so that is why we have seen everything with open eyes. How it goes on.
So what to do?
No, my lord, there is some urgency, my lord. Let it, my lord, on it.
He is a pescar.
He is not having any urgency because till now there is a no environmental.
No, but my lord, there is, my lord.
Pressure is somewhere from somewhere else.
No,
Okay, list this due to paucity of time, matter could not be taken up. However, the learned counsel for the parties has expressed urgency in as much as Mr. B. Chaudhuri, learned counsel representing the BTC, submits that he is having the required record.
Required.
Required record. The record be kept by Mr. Chaudhuri. List this matter on after 2 weeks give a date.
5th of March.
5th of March. No, it's a give a date.
5th of March is a Tuesday.
Give a after 5th of March. Give a date.
6th of March.
6th of March.
I'm 5th of
Over.
Very clear.
Sir,